Any mention?
May it please your lordship. Your lordship, I beg to mention item number 3.
Number 3.
Lordship, I paid for 2 weeks time in this matter.
Why? You're the appellant.
Yes, your lordship.
No objection, lordship.
No objection. No, this is a disease here. Yeah. After 2 weeks. Yes.
Supplementary cause list, item number 1.
What is for affidavit? I'm paying for some more time.
Why, Dr. Mozika?
Well, because my lord, I received a letter that since Union of India also party, they've referred the matter to Delhi, my lord, from Ceylon office.
What's the matter about?
No objection.
Yes?
No objection.
It's a GST matter.
Okay, as prayed further,
3 weeks time.
3 weeks time is allowed to the respondent to file affidavit. Is there after and so and so?
Okay.
Item number 2.
Lordship, here the counter affidavit is ready, Lordship, and I'll be filing it in the course of the day, Lordship.
Yes.
Today.
Mr. S. Pandey submits that the counter affidavit on behalf of the respondent ready and the same be filed in the course of the day. Then you want to file rejoinder?
Yes, I'll file.
Yes, Mr. Ansupta, please.
Within 1 week.
Fill out for rejoinder within 1 week. Yes, after 2 weeks, yes.
Much obliged, Lordship.
We have 7 minutes.
Any mention?
May I please, Your Lordship? Your Lordship, I beg to make a mention of item 23.
20?
23, Your Lordship. Your Lordship, I pray that this matter may come up for 2 weeks.
Twenty-three.
Your Lordship.
You are with whom?
Mr. Nongri, Your Lordship. He's currently on a sanction
No,
leave.
this much.
Okay, 2 weeks. He's gone for holiday.
Yes, Your Lordship.
Fair admission.
Hello, Your Lordship. Your Lordship, similar prayer for item 25.
25.
Yes, Your Lordship.
25, you have no objection?
No, Your Lordship.
Yes? Yes, Dr. Saraf? Item 3 is in the order column. We'll take it up. We'll take it up, yes?
No, but I pray for 10 days adjournment because there is no problem with the matter.
Okay, yes. After 10 days. Yes.
I was
Yes, we'll record. Yes. Yes. MSM Hojong. Anything to say? Yeah.
Your Lordship, I beg to mention items 20 and 21.
This matter. Where Dr. Muzika? Your objection?
Let's keep
Recuse other, we can finish it off. What is there? Service matter, correct?
service matter.
Then,
Your Lordship, I'm praying for 1 week's time.
okay, 21 week.
Obliged, Your Lordship.
May I please, Your Lordship, I beg to mention item number 28, Your Lordship. In
Number?
this- 28. In this matter, we need to file a rejoinder affidavit. We already have filed it.
You filed it.
Yes, Your Lordship.
So then, where's the MSTIE? Ready with the matter?
I humbly pray let this matter come after 2 weeks, Your Lordship.
You filed a rejoinder?
Yes,
Are you ready for the hearing, that means?
We received the rejoinder today, Your
Today
Lordship.
itself.
After 2 weeks, yes. A rejoinder has been filed by the petitioner. Yes. Yes.
Much obliged, Your Lordship.
Yes.
Lordship, I beg to mention item number 26. Lordship, conducting counsel could not appear because of some medical emergency at his place.
Who's the conducting counsel?
PB Gordon.
Okay, yes. After 2 weeks, yes.
Lordship, after 3
Okay, 3 weeks. Yes.
obliged.
Yes. Fine.
Supplementary list item number 1.
May I please,
Yeah.
Your Lordship? This is an application for appointment of
Section
arbitrator.
11.
Yes. Well, in fact, this is similar case which Your Lordship has in October appointed an arbitrator. Exactly same case, similar case, my Lord.
Let them take instructions. Next day, we'll appoint arbitrator. Okay. Heard MSPDB for the
Next week, my Lord. Fixed.
Next week, yes. So you take instructions. Use a similar case, then we appoint same arbitrator only.
Not the same arbitrator because it's a very huge matter, my Lord. There are 6 different contract
So which
agreements. So we
arbitrator
have
you
already
have in mind?
suggested 3 names to the
What are the
department.
3 names?
The 3 names were already there in a petition or application also. One is Mr. Sudhir Kumar, Rakesh Kumar Agarwal, and one Saurav Mathur, my Lord.
Yes, Saurav Mathur seems to be popular. All the
Not been
lot of arbitration handling.
appointed. Saurav Mathur, we have suggested, my Lord.
He has
Even
been-
in a petition for appointment of arbitrator, we suggested this name.
So many sections. Bagdogra.
There are almost 5 different contract agreements, but given under one same contract. And almost 350
Are they all been
crores.
completed?
Was completed, everything, but the final bill has not been paid. Even deviation order has not been submitted till date. They have not passed. And we gave them the notice for appointment of arbitrator.
When?
On 1st May, we have given the dates. And already 30 days have expired. They neither settled the final bill nor they have appointed any arbitrator, my Lord.
Yes, I heard MS P. Bazarpurwa for the petitioner. Dr. Nekpan, Dr. M. Muzika is present on behalf of the respondent for the notice required. She submitted that this petition under section 11 bracket 5 11(6). This is a petition under section 11(5) 11(6) of the Arbitration Concession Act. So appointment of arbitrator. The next paragraph, it was a phrase allowed 1 week's time to obtain instructions. Yes, we won't record right now arbitrators, and we'll finish it after 1 week. After 1 week.
Obliged, Your
For instructions.
Daily list item number 1.
Please, Lordship, as per the last order dated 25/2025, I filed a condition of delay. Actually, there is a actual delay was only 50 days. Actually, from the date of filing the appeal.
Can I file objection?
Yes, Your Honor, but it has not listed today, Your Honor, that continuation of delay in this case.
Not listed today.
No, Your Lordship, it's not there because.
Yesterday we have filed it.
Yes, you file. Anyway, you take notice.
Notice.
Yes, though this miscase review petition 1/2025, though the matter is not listed today, Mr. SD accepts notice and prays and allowed 2 weeks' time to file objections to the condemnation application.
Lordship.
Just after 2 weeks. Yes.
Lordship. Lordship.
Any private respondents?
Yes, there is a private
has to go, my lord. Also to go private respondents.
Much obliged.
Item number 2.
Please, my lords, the conducting counsel has met with an accident.
Who?
Mr. Bora.
How is he?
I'm not sure of this
When
gravity of.
when? On the way to court?
My lords, yesterday also he was not present.
Oh. Even a motor accident?
I'm not sure of the gravity of the accident or
What kind
the
of accident you don't know?
No, my lords.
He submitted that the arguing counsel, Mr. Bora, is not available due to. As Mr. P.K. Bora, Leonard, counsel for the priest is not available today, list the matter for 2 weeks.
Obliged, my lords.
Item number 3.
Yes, 3 already adjourned. 3 under pre-out of the case are off. This is a matter for 10 days. Not objected to by Mr. Advocate General on behalf of the respondent.
Item number 4.
Yes.
Item number 4. Your Lordship, it seems like they have complied with the judgment passed by the
We have complied with the order.
So we'll close it.
Yes, sir. Your Lordship, you can close it.
MS A. Harmonize submits that the order stated to be violated has since been complied. He pleads that the contempt application be closed. According to submissions, contempt stands closed and disposed of here.
Much obliged, Your Lordship.
Item number 5.
May I please, Your Lordship, humbly pray another 2 weeks' time, Your Lordship, to file the affidavit.
2 weeks for the time. How many times you prayed?
So many times.
6, 7 times.
No, Your Lordship.
So the
Just-
appeal is pending. This up to 3 weeks. As an appeal against the order stated violated pending consideration before the revision bench. Yes.
100%.
6.
Please, Lordship. Lordship, we won't be filing an affidavit, Lordship.
You won't be filing?
No, Lordship.
Then he prayed for time. Who are the other respondents? MS Marpan, number 6, yes.
Yes, I would need some more time, Lordship.
Why?
Because there are certain correspondents are in vernacular language, so we need to do translations. Just give us 2 weeks time.
Mr. J.K. Paryat, Leonard Counsel for respondents 1 to 5 and 7 submits that no affidavit will be filed by these respondents. Mr. S. Marpan, Counsel for number 6, please without 2 weeks further time to file affidavit as to enable him to complete the translation. Yes.
May please, Your Lordship, may the interim,
yes,
may the interim order continue.
2 weeks, interim order of any shall continue till next date.
Highly obliged, Your Lordship.
7.
The respondent is yet supposed to file affidavit.
Who?
The respondent.
Where was the Kharwanlang? Where was the Kharwanlang? Is a contempt matter? No one's appearing. Then we direct for appearance of the contemptor in person.
I tried to appear in this.
Already appeared last time, Mr. Kharwanlang.
Yes, my lord.
What's the order saying violated? Where's the order? Where's the order?
I apologize, Your Lordship. I don't have the brief.
You come out a brief.
Yes, Your Lordship. I apologize, Your Lordship, because the chamber was closed, Your Lordship, this morning. That's why I cannot get the file. I apologize, Your Lordship.
Yes, as prayed further 2 weeks time allowed for affidavit.
I will find out what is the status of compliance, my lord.
Yes. 2 weeks
No, but-
for affidavit, yes.
8.
Yes.
But this is a matter, my lord, the petitioner was discharged from service on the ground that he attempted to commit murder.
Did you
my lord,
File an affidavit, my lord.
have you filed affidavit to show when it was communicated to him about the setting aside of these
Yes, ma'am.
summary court proceedings, Assam court proceedings?
But here what happened, my lord, the impugn order has been recalled, my lord. I placed an earlier
Call,
occasion, my
yes,
lord.
but the
My lord,
petitioner says that's not his knowledge at all.
My lord, it appears, my lord, he's right, my lord.
He's right.
Yes, my lord.
Then what should we do?
May I just place it.
We inflict
My lord,
cost.
he can go and join now also.
My lord, here the joining it's okay. My lord, I have prayed for the back wages also.
Of course, he'll be done back.
Definitely,
wages.
my lord.
All consequential reliefs.
Definitely.
From the date, my lord.
From whatever date of reinstatement
My lord, from the date of discharge, my lord.
of the discharge.
My lord.
You discharge because you tried to commit suicide, correct?
My lord, that's an allegation, my lord. That's an allegation. We have challenged that, my lord.
Then take down Dr. N. Mozika and DSGI today fairly submits that it appears that
Because
no
of some
communication was made to the petitioner about setting aside summary Assam Rifles Court proceedings, and also where that and that the order dated 11 September 2024 reinstating the prisoner's service. As such, the order dated 11 September 2024 reinstating the petitioner's service would not be so as such the petitioner was not aware about the order dated 11 September 2024
As well as, my lord, October.
as well as 17 October 2024. Reinstating the petitioner's service. Stop. Next paragraph, Mr. R. Jha, on his submission, praised that the petitioner is ready to join back into his post. No, please submits that the petitioner is ready to join back to his post. Only that may be allowed all consequential benefits from the date of discharge. When was he discharged?
My lord, he was discharged from service on 31st May 2023, my lord.
2023. Stop.
my lord, that period, my lord.
We leave it to you for you to consider.
Right.
Yes. If you join first, you take your back wages from that is from 17th October. Correct? From 11 September.
11 September.
You take 11 September 24, and for the remaining period, they will consider it and pass.
He submits a
orders.
representation, my lord.
Okay. You accept that or no?
Lord, that's again fresh round of litigation we have to come, my lord.
But at least you'll be in service. You'll have some money in your hand. Yes, no? But that he be allowed all the consequential benefits such as back wages from the date of his discharge, that is
31st May 2023, my lord.
31st 05/2023. Stop. Next paragraph. It is noted that by order dated also did that on the previous dates, the London DSGI, Dr. N. Muzika, had produced a communication dated 9 May 2025, wherein it was indicated that the impugned order dated 31/5/2023 had since been set aside by an order dated 11 September 2024, and also consequent thereto, the writ petition had been reinstated. Stop. It appears, however, as submitted that due to inadvertence or oversight, the said orders were never communicated to the petitioner, which caused him to approach this court by way of the instant writ petition. Stop. In the circumstances, therefore, this writ petition is disposed of by directing the respondents. Where is he posted right now?
My lord, he is.
Where will he be reinstated?
He will be in the from the unit where he was from discharge.
He will be reinstated into the unit from where he was discharged, and also will be entitled to back wages and other consequential reliefs from the date of the order dated 11 September 2024. Stop. As to the early period, that is from 31/5/2023 to 10 September 2024, the respondents are to make considered decision for a grant of back wages, and while dealing with the matter shall pass a speaking order thereon. Yes, the petitioner
if he submits a representation,
permitted to file representation in this regard. With the above, as ordered above, the representation stands closed and disposed of. Yes. Copies of the communication dated 9 May 2025 is taken on board, made part of the record. Yes. Have you got the 9 May now? You've got that order? Yes.
My lord, I have.
Item number 9.
You filed affidavit.
Yes, sir, for that.
Received the affidavit.
You want to file rejoinder or no?
No, rejoinder is required. The matter may come up after 3 weeks for hearing.
Submits that no rejoinder will be required. We praise that the matter will be listed for hearing. Accordingly, this is a matter for hearing. Next line, also, yes.
10.
Here also you filed affidavit.
Your Lordship, I'm praying for 3 weeks' time to file my rejoinder, Your Lordship.
Rejoinder?
Yes, Your Lordship.
MSPG3 praise for about 3 weeks' time to file the rejoinder affidavit filed by the respondent.
Oblige, Your Lordship.
11.
The respondents are yet to file their affidavit, Lordship. Please, Your Lordship, I humbly pray another 2 weeks' time to file their.
When was the matter filed?
It's a new matter, Your Lordship. 25, Lordship. It's my 25. Third time, Your Lordship.
I'm appearing on behalf of SK Hassan. I'm praying for 2 weeks.
Which is 5 to 7?
5-6.
Last opportunity. Yes, MSS Marpana, right?
Yes, Your Lordship.
Praise for was allowed further 2 weeks' time to file affidavits. Similar prayer made by MR Marak on behalf of 5 to 7. Stop. Praise allowed. Next time expected, next day, the affidavit should be on board. List on so and so.
Highly obliged, Lordship.
12. 12.
I'm praying for some more time, right?
3 weeks further time was placed allowed for affidavit.
13.
Same for 13 months.
Giving them 1 week extra because of the time take to communicate to get signatures.
14.
My Lord, the state prays for 3 weeks' time, my lords.
What's the matter about?
Lordship, here petitioner has applied for the post of assistant teacher, Lordship.
What about service on this 4, 5 and 6?
Lordship, I will file during course of the Lordship.
Service affidavit?
Yes, Lordship.
Lordship, you have only entered appearance on behalf of respondent number 6. I will respond.
Today?
Yes. No, I've already filed for plan.
It's not recorded here.
I filed earlier.
4 and 5, not 6.
No, I'm for the only 6.
And 4 and 5.
Okay, then yes, okay. Yes, Mr. Karnong Bak is present to be respondent number
6.
6 and your name, sorry, and MS CR Moplang is present on behalf of respondents 4 and 5. As such, notice complete and all the respondents stop. MS Syam for 1, 2, 3 plays for
3 weeks, my lord?
no 3 weeks.
2 weeks, my lord.
2 weeks to file affidavit. Similar prayer for you.
Yes, sir.
Similar prayer by the councils for 5 and 6. Prayers allowed it after 2 weeks.
Obliged, my lord.
15.
Please, Your Lordship, I humbly pray I needed 2 weeks' time to file the affidavit, Your Lordship.
What about number 4? Served?
Yes, Lordship.
It's been served?
Yes, sir.
Yes, affidavit indicating service respondent 4 has since been filed. Stop. Has since been filed, comma, but no appearance made as a respondent today. Stop. MSS Marpana next and prays for on behalf of respondent 1, 2, 3. Prays for further 2 weeks time for affidavit prayers allowed. This after 2 weeks for affidavits by 1, 2, 3.
Yes.
For appearance respondent number 4. Yes.
Much obliged.
16.
May I please, Your Lordship?
My lord, here the last order says, my lord, that we need to produce the record. The record I have received, my lord, yesterday, and moreover, I have been also instructed to file my affidavit. So I'll pray for 2 weeks' time, my lord. On the meantime, I'll classify the record also.
You're for 4 and 5.
I'm just praying for 10 days' time, my lord. I'll file.
Mr. S. Day, then counsel for respondents 1, 2, 3 submits that the records have since been received, but submits that counsel, but he requires to file an affidavit on behalf of 1, 2, 3. Accordingly, 2 weeks, 3 weeks, or 2 weeks time allowed.
Hello.
Yes, 2 weeks.
17.
Affidavit by respondents 1, 2, and 3. One by already filed.
Here I'm praying for a little more time for instructions, my lord. My lord will appreciate the fact that in this case I have a simple prayer, a simple direction to them. Let them take a decision either way or the
whether
way.
he approves or not the minutes.
Yes.
So you can't get telephonic instructions.
Telephonic also, my
You
lord.
can't get instructions telephonically. Also, this was listed last on 2nd.
My lord, let it come up after 2 weeks, my lord.
And
Sorry,
moreover,
2 days.
my lord-
I'm praying for 2 days, my lord. Because I
See,
spoke
look at
to
the
him.
prayer.
My lord. I have seen, my lord.
Then?
Now the question of whether post facto approval, where is the provision, my
just
lord?
whether what decision to dispose of letter application 21.3.25.
Dispose my application, my lord. Either way.
Yes or no? Dispose it off.
Kindly allow me
And
2
moreover,
days,
my lord, kindly appreciate
You can't get
the
instructions,
the
Mr. Bharat.
tenure of
My lord, I have already
the
spoken-
existing committee is going to
I will
expire by
call him
31st.
tomorrow.
I have
Who's the
already
person?
spoken to them, my lord. Kindly
Who's
allow
the
me 2 days.
concerned person? Number 3. Let them appear tomorrow.
So, my lord, here,
let him appear.
my lord, I have contacted the directorate office, my lord.
Let them appear.
So, my lord,
Because
kindly-
I'm going to help you all because it seems you have difficulty in applying instructions. Maybe they do not,
No, my lord, what had happened, my
attach
lord,
our importance to court cases and to government advocates.
No, my lord.
So if we issue these directions now, if they have to appear time again, then at least they'll be they'll be more alert.
My lord, what had actually happened, my lord? Only recently the office of the directorate got the letter, my lord, from
Doesn't
the
matter.
from
Those are
the
instructions you've
office
got.
there. So, my lord, kindly allow me 2 days because just.
Otherwise, we can't have a.
My lord, I understand what has fallen from my lord.
machinery, function like this where they don't care for the court cases, they don't care for the panel lawyers. They just You're saying take 2 weeks time, 3 weeks time. Can
My lord, I have already spoken to them, my lord. Because the office, directorate office here also just received the letter. My lord.
He submits that. Please
Let me on Friday, my lord.
Yeah, this matter on Friday. Otherwise, once we pass those orders, then you'll see that once you ask for instructions, they'll come like this in the same day. Or once the case is filed, before even taken up by the court, when you ask for instruction, you'll have instruction in your hand when the motion is taken up. That should be the way actually.
18.
Obliged, will be obliged.
Not against any consequences that. Otherwise, it's happening all the time.
Obliged.
Mechanically, they all panel advocates ask for time. Yes.
Your Lordship, I'm appearing for the bank in this matter.
Where's the petitioner?
The petitioner had called me in the morning and told that some difficulty to come to Shillong. So the matter can be listed by tomorrow.
What's the matter about?
Actually, here there are two partners. So one partner has gone ahead and
blocked
I blocked the account.
You're appearing for the bank?
Yes, Lordship.
Yes, Mr. Adhar has appearance on behalf of all the response 1, 2, and 3. Yes, this after 1 week.
Tomorrow, Lordship, if it's possible.
None appears for the petitioner. Mr. Adhar and appears on behalf of the respondents 1, 2, and 3. However, no report is available yet with regard to service upon respondent number 4. This after 1 week is for service report.
Supplementary list item number 2.
Yes.
My lord, yesterday with profound patience, Lordship has heard us, so that they will not take a long time and I'll shorten the argument. If Lordship give me some latitude, I'll just point out the miscase.
We can't shut you down.
Well, I'm grateful. My lord, the case is very important matter. My lord, the miscase we filed to strike out the writ petition number 27, my lord. Lordship may take notice of in the first writ petition. Miscase number 125, my lord.
Take down, who's there?
My lord. Yes. Writ petition 27.
This is in 496.
Yes.
Miscase number 100.
My lord. Miscase 100.
Miscase number 100/2025 in WBC number 496 of 2021. So this is an application seeking for striking off the name of the existing writ petitioner number 27 from the array of parties in the main writ petition on the ground that as she has already received the compensation, she is no longer willing to pursue the matter. Obviously not objected to by the counsel for the respondents. Accordingly, the name of respondent numbers, the petition number 27, that is Srimati Pirotan Song, shall be struck up from the array of petitioners. In this case, so accordingly allowed and disposed of. Registry to make necessary correction and the court title. Yes.
Great. My lord, since my lord, will Lordship.
You want to address any more 496 or you have?
My lord, I have prepared the bullet points. My lord, that will save the time I have incorporated. I may straight away go to the second writ.
150.
My
lord. Yes.
The 150, my lord, the short issue involved is, my lord, when the section 11 and 19 notification is subsistence, whether the respondents taken. Section 11 preliminary notification and Section 19 declarations are in subsistence. Whether the government can issue another similar notification on the same plot of land without cancelling the first one.
Or the question is, okay, subsisting notifications.
Yes, subsisting notifications, whether the second notification is permissible to be issued on the same plot of
11 and 19.
Yes.
For a same plot of land?
Yes.
Or tenable or maintainable, okay. And
My Lord, to substantiate that it is not maintainable, my Lord may kindly come to page number 43 of the first Section 11 notification for Sankat. This was published on 22nd June, though notification is 2nd June. Sankat village.
Yes.
And the Section 19 declaration for this matter is also available.
This is 22nd June, correct?
My Lord. It was 1st June, but published in newspaper on 22nd June.
Okay. Published on. Yes.
My Lord. And Section 19 declaration.
It says that for 70,250 square meters.
Yes, meter is required as Sankat village.
Sankat village.
My Lord.
Okay.
And Section 19 declaration is available, my Lord, reflected in page number 49. The letter issued by collector. The notice. When he issued notice, because the copy is not supplied to the petitioners, but they have clearly mentioned that.
Annexure 3?
My Lord, Annexure 3, page 49.
Yes.
My Lord, from five lines from the top, declaration number since 24th August 2021.
This is dated?
My Lord.
It is dated when, Mr. Changrai?
In the middle of the line, my Lord. Declaration dated 24th August 2021. In the middle, right? 1, 2, 3, 4, 5, 6. 6 lines from the upper, my Lord.
24th August?
My Lord. Is a declaration for the Sankat village area.
On 19?
My Lord.
(24/8/21). Yes.
Madam. And further, the details
and
are.
This is a special notice under Section 21.
Yes, yes.
Section 40.
Yes, not 40. But they have invoked the urgency clause. My Lord may come, the detail is available in page number 68, Annexure 9, for the entire villages. 7 villages. My Lord, later written to the lawyer, my Lord. In drawing your kind attention to the subject cited above, and your letter dated such time request you to kindly issue a no objection certificate for the purpose of land acquisition for construction of the Indo-Bangla border fencing from Oktapur to Chalaikola covering such and such. It may be mentioned that preliminary notifications. Now, details of preliminary notification, my Lord, Sankat is 7th June, my Lord. 7th June, I stand corrected, my Lord. It is not 2nd June. 7th June for Sankat.
We noted 7th June, okay?
7th June, my Lord. And for Muktapur and the rest of the villages is, my Lord, 18 February 2022. All these were issued, my Lord. And in this regard, I am also stated as per information received, any compensation is to be transferred in the name of the such the lawyer on behalf of the Lega. In this connection, I also request you to kindly submit a power of attorney authorizing the lawyer to receive the compensation on behalf of the Ilaka. Now, in all these Section 11 notifications, the lawyer is not the features. All the individual landowners are including writ petitioners. And here is internal communication. The collector asks him to submit a power of attorney to receive. In fact, on behalf of those landowners.
So, Section 11 initial, no mention of the lawyer?
No mention of the lawyer. No mention of the lawyer.
Only by this letter?
My Lord.
Only by Annexure A9.
And if he is a landowner, in fact, it is not required to produce a power attorney. He can receive.
It is a direction that his regard will also state as per information received.
Yes. So he
what
said
information received?
That is fine. But in fact, my Lord, since the first petition is pending, my Lord, and petitioner is asserting their rights, there was an internal communication between them to sideline the petitioners and rob in this gentleman and try to settle the issues behind. That is a game engineer plan, in fact. But
so there's something else.
Yes. So when this, my Lord, is pending, my Lord, the
so that is this Daloi is of the Sarpator.
Sarpator.
So you're the person who's going to take all the compensation.
Lordship, these 7 villages, they falls under the jurisdiction of the Daloi.
No, but then from individual landowners, it's not community land.
No, they are not landowners. I'll come to
They are
not land.
He will hear him. He will hear you.
Well,
Just that only. No. See, it's a submission that senior counsel has made that in section 11 notification, you're nowhere in the picture. But now by this 15 March 22 order or whatever, it's addressed to you.
Lordship, section 11 pertains only to whatever my learned senior has showed, Lordship. Only pertains to Sankhat.
Sankhat is.
Not other villages. I'll come to that.
yes.
No, we'll hear you.
These 7 villages, my lord. So this letter was issued on 15 March, and subsequently, my lord, may come to page number 75, the affidavit filed by the collector himself in the first writ petition. 75.
Yes, your writ petition.
In the writ petition, my lord.
Yes.
Collector has filed this affidavit on 8 August 2022. And in view of this previous communication, my lord, he has highlighted page number 87, my lord. There he has mentioned the lawyer's name as a landowner in his affidavit.
87?
87, my lord. In the table, my lord, from serial number 9
From
onward.
9 to...
9 to, my lord, 15, there's 7 villages.
Yes.
Mentioned as a Doloi. At this time, my lord, notification not yet issued in his name. Now, coming to know that, my lord, there is no notification in his name. Therefore, they have taken further steps to issue section 11 notification again. That is available in page number 100.
So you mean to say that this is affidavit was filed on 8th
August
8th August
2022.
22. And this letter is?
That letter is, my lord.
A9?
15, my lord.
Date is?
15 March 2022.
That means it's before the affidavit.
Yes.
When the action
yes.
A9 was issued.
Yes, yes. There was a communication between them.
Okay, yes.
Yes. And now
to show that when this A9 was issued,
yes,
the lawyer's name was shown, and so does also reflect in the affidavit also.
My lord, he has filed affidavit mentioning the lawyer as a landowner. Okay. But realizing that, my lord, there is no notification in his name. Therefore, the respondent state has issued another notification which we have challenged. Page number 100. My lord, it is 13 March 2023.
Yes.
My lord.
It's under section 11 again.
My lord. And content of the same, my lord. Government of India Home Affairs is pleased to notify the public that the land measuring about and such is required at Muktapur, Laikro, Hatiula, Hawaii-Tiula, Espitela, Sankat, Chalaikola, and Pesatwa. These 7 villages mentioned. The first time. And the name of the lawyer is mentioned in the subsequent page. And the name of all the writ petitioners and others who did not come before this court were excluded. So that the compensation would be paid to these gentlemen and they would proceed with acquisition.
Where's your village? Sankhat.
Sankhat is, my lord, it is not mentioned. It is not mentioned in that table, but it is mentioned in section 29, section 19 declaration. That is page number 106. In the table, it was missed out, but in the notification, it is there.
Yeah.
My lord, page number 106. All these 7 villages they have mentioned here. Sankat also mentioned in serial number 4 in that table. The same plot, same area. Now the question why they issued this notification during the subsistence of those 2 earlier, my lord. Now they have filed the affidavit. My lord, may allow me to take lordship attention to the affidavit filed by the collector himself in this WPC, which he has filed on 3rd April 2025. The ground taken by the collector mentioned here is available in para 11 of his affidavit. And this is the only ground.
Is the affidavit 167?
Well, they call it state respondent, but it is not a state respondent. I will show, madam. Affidavit Kumar Singh is a debt collector.
Yes. What do you want to show?
My lord, para 11, para 10, my lord.
This is a respondent number.
My lord, he is the respondent, but the collector.
Number 2.
No, my lord.
789. Filed on 3/4/25.
My lord, respondent number 5.
Filed on. So many affidavits here. Filed on 3/4/25.
3rd April. 3rd April. He is respondent number 5 in the writ petition.
Yes. Abhinav Kumar Singh.
My lord.
Yes.
He is the number 5 in the writ petition.
Yes.
Now, para 12, Lordship, can you see the ground, the single ground taken by the government, it appears.
Dispute question of fact.
Well, with regards to averment made in para 4 of the petition, it is respectfully submitted that it appears that the petitioners have merely made a averment that they are the landowners and that most of them have land holding certificates issued by district council and customary land documents without actually enclosing any documents. On the other hand, respondent number 6, the third part supporter, through its Deloitte, has submitted agreements pertaining to cultivation rights. Further, the answering deponent respectively states that since respondent number 6 have stake claim over the land from Muktapur to Pasarwar, white letters and such, as a fresh notification was issued by Revenue Disaster Management. So the only reason for issuing that notification is he is claiming ownership. Now, my humble submission to this effect is this, my lord: if he claims that he is one of the landowner, adequate remedy forum is available. Reference coordinate, section 64, section 76 is available. Party can go there. But if this is the permissible ground, then one day, my lord, Mr. Z come forward again that the land belongs to me. Can the government issue another notification? It cannot be done. It cannot be done. We have the land acquisition has properly provided the adequate mechanism to deal with this situation. But this they have been done so as to prevent the presented petitioners from pursuing their matter. I would place one judgment before, my lord. I will take the after, my lord, I take the effective rejoinder. My lord, an other issue with regard to who is entitled, whether the law entitled, petitioner entitled, or the other private respondent entitled, forum is available. Party can go there, my lord. I'm not assailing that action. Forum is available, my lord. Now, only my assailing, I'm assailing that second notifications do not arise on this particular ground. My lord, may I take the lordship permission to the rejoinder, short rejoinder we have filed? I'll clarify one point. And my lord, I would take my the two authorities I would cite to satisfy my lord. Now, I have annexed those land documents, others, even the land documents signed by the Deloitte himself, I annexed, but I will not respond. This is not the forum, my lord, to educate that issue. I would humbly submit that, my lord. If I may take my lord attention to the RTI, the reply of the RTI, because these three petitions are connecting to each other. My lord may come to page number 107. 107 of my rejoinder affidavit.
107 rejoinder affidavit here?
Page 107, yes. Because I have annexed all this land documents, therefore it lengthened the rejoinder. The rejoinder we filed on 5th June 2025. Because the affidavit of the collector say that the people were consulted, local residents were consulted,
okay,
and government.
What do you say? Page?
Page number 107, annexure. Annexure 2. Now, by this RTI application, the petitioner sought as to when the government of Meghalaya has given a consent to the government of India to go ahead with the boundary dispute settlement. Detail were sought.
Yes.
My lord. And the reply was given, page 110, reply was given.
200 and?
110. So the department said that those informations are not available with the department.
You have said, can you listen if we end?
Copy of decision taken adopted by Cabinet State Government of India with regard to no objection given to the Union of India for settlement boundary disputes with her Bangladesh counterpart. So this is very vital because the government say that public has given mandate, has given consent. So how will government secure? Government of Meghalaya need to secure the consent of the people through public meeting. There is nothing as such. So information was sought and the reply was available, is available page number 110. They say that that information is not available. So my humble respectful submission is that there is no such a decision taken by the competent authority of the state to go ahead with the finalization of the boundary also. Now with regard to the with Lordship permission, the RTI placed before the District Council for issuance of NOC. Yesterday we addressed that issue also. RTI was put up before the District Council as to when the District Council has taken decision to revoke and given NOC. Page number 111 of the rejoinder, same rejoinder.
Not the 282.
My lord.
Or 11 is
111, my lord. 111.
Yes.
My lord, I may take Lordship attention to point 3. Copy of the proceedings for sitting of the Executive Committee meetings and minutes or resolution adopted or taken by the Executive Committee of the JGDC for issuing the letter dated such and such. 1st July is the, my lord, is the one we are challenging the first rate petition, saying that the NOC they have given in 2015 is in force. To the Deputy Commissioner Jawai, in 2015 they have given NOC, 2018 they withdraw because of the public was not consulted. Then subsequently, my lord, 2021, they have sent one letter to the DC that no, my NOC is still in force. So now because of that, detail was sought. And the reply has been given, the next page, my lord, page 112, 112. And the type copy 113, my lord. It says, my lord, letter dated 3/4/2018 of the Deputy Commissioner against the withdrawal of the NOC for acquisition of land for such. The Executive Committee placed the agenda, the Executive Committee, and briefed the meeting of the letter dated such Deputy Commissioner, who inquired of the provision of such Act, which enabled the Council to withdraw the no objection certificate issued earlier. He then called upon the Sri Sansach Deputy CEM and local MTC to highlight the matter to the meeting. The Deputy CEM addressed his concern of the matter that involved national security and referred to the eligible in the last para of the letter that stated that no harassment or ill treatment was eligible for any land owner, which is not at all true. Assistant Law Officer read out Article Section 413 such of the Act 2013 and explained that there is no relevant section of the Act which withdrawal of the objection certificate issued, and that complaint, if any, shall be filed to the district collector. The Executive Committee deliberately discussed the matter, and on the assurance of the Chief Executive Committee member in collect writings and complaint from the landowners and public within the 10th May 2018 for submission to the Deputy Commissioner, it is decided to request the DC to await till 15 May for reply to this letter. Now, subsequently, the next statement, my lord, Deputy CM says, as per the decision above, we are assured to furnish writing and complaint from the landowners and public with respect to reply to be made to the Deputy Commissioner regarding the withdrawal of NOC should be NOC from the port of fencing. The Deputy Commissioner has been requested to await till 15 May 2018 for a reply from the office. This is the noting, my lord. The last one. Please therefore furnish the said information complaint for submission to the Deputy Commissioner. Now, what I'm trying to say is that, my lord, this is after they withdraw the NOC. After withdrawing NOC, they set for a meeting again, Executive Committee, as to whether that NOC given to them should be made alive or not. This is the meeting. Now, this meeting, the Executive Committee never take a decision to issue that this 1st July 2021 letter. So my humble submission is that, my Lord, the District Council Committee, my Lord, the competent authority did not take the decision at all to revive that NOC. Mere receiving one letter from the one officer of the council will not amount to satisfying the requirement of, my Lord, Section 41. And that Section 41 is very vital. It is a safeguard for the tribunal. And had they seek that proper consent, normally District Council take the they consult with the stakeholders, and after finalizing examining the ground reality, they used to give. This has not been done.
Yes.
So my first ground yesterday writ petition that no NOC was issued. I'm my Lord, reiterating that point, my Lord. Now I'll place two decisions only with regard to, my Lord.
This subsequent notification.
Yeah.
You're more concerned with whether
yes.
You're seeing multiple notifications after Section 11, Section 19 were already issued, and now subsequently to facilitate the payment compensation to one entity.
Right.
So the subsequent notification issued, which you see it's not permissible. Correct.
Right.
Yes.
Right. So I will only cite two authorities. One is with regard to the notification, repeated notifications, and second is, my Lord, here the collector do not represent the state, and the state do not file any affidavits in both the writ petitions. I will cite, my Lord, the first issue, my Lord, that is with regard to notifications, my Lord, 1980, Volume 1 SSC.
91980.
My Lord, 1981 SSC, page 308. Relevant para would be 10, my Lord. Para 10. My Lord, my humble contention is, if previous Section 11 or Section 16, Section 19 declaration is invalid, in that case, my Lord, normally
You mean to say subsequent is invalid?
My Lord, subsequent is invalid. Now,
but the earlier one only refers to one village, Mr. Chandraso.
My Lord, the copy we have annexed one village.
village.
My Lord.
But your contention is that there were same notifications for all the villages.
Yes.
Where are they?
My Lord, that the copy they don't provide, but the collector letter itself shows that they have issued notification, and they are not disputing the affidavit also. Collector is not disputing this position. He filed his affidavit. He's not disputing. He didn't say, no, I never issue.
Let's see what does the decision say.
My Lord may come to para 10.
Yes.
Normally, my Lord, if it is invalid, then the government can issue a cancellation. Then they can proceed for new one. My Lord, I think para 10. The contention was that by cancelling the first notification under Section 6, the government must be deemed to have withdrawn from the acquisition and cancelled the notification under Section 4, and therefore could not issue the second notification under Section 6 without issuing a fresh notification under Section 4. It was also urged that the power of the state government to issue a notification under Section 6 was exhausted, and the government could not issue a fresh notification under Section 6. The court rejected both the contentions, observing, having regard to the proviso to Section 6 of the Act, a declaration for acquisition of the land for public purpose could only be made if the compensation to be awarded for it was to be paid wholly or partly out of the public revenues or some fund controlled or managed by the local authority. The government had no power to issue a notification for acquisition for public purpose where the compensation was to be paid entirely by the company. The notification dated 1961 was therefore invalid and of no effect, such and such. The appellants filed a writ petition challenging the aforesaid notification on this ground. Challenge was justified and the notification was liable to be quashed by the court. State government realized that the notification was invalid and without awaiting for an order of the court, cancelled the notification on April 28, 1964. The cancellation was in recognition of the invalidity of the notification. The government had no intention of withdrawing from the acquisition. Soon after the cancellation, the government issued a fresh notification under Section 6, where in this case, the notification under Section 6 is incompetent and invalid. The government may treat it as ineffective and issue a fresh notification under Section 6. This is what, in substance, the government did in this case. The cancellation of such was no more than a recognition of the invalidity of the earlier notification. The first notification of such was obviously invalid and of no effect. By the issue of this notification, the government had not effectively exercised its power under such. In the circumstances, the government could well issue a fresh notification.
So you say that they should have cancelled all this
notification? Normally,
if they were to take recourse of second notification.
My Lord, that's why I'm trying to emphasize, my Lord. If the first notification is invalid,
It's faulty, you mean?
yes, faulty and invalid on proper ground as per the law, they can cancel it and come up with a fresh notification. But here, my lord, did not.
So you say that the issuance of your two notices can't run concurrently.
Yeah, exactly, my lord. My lord.
But then how is that first one in conflict with the second one? Because the first one, the landowner's names are given.
Names are given.
And the second one goes to Doloi.
Only Doloi. Only Doloi.
So won't that be a matter that can be taken up by the reference court?
But therefore, my humble submission, the second notification required to be set aside. And if anyone has a grievance, along with the petitioners and even others also, there is a remedy for them.
So you are resisting the, release of compensation to Doloi?
My lord.
By saying that yes, so since the other names are given there, so the Doloi by default cannot by
Exactly. Now, this second authorities I want to cite with lordship permission is that the collector do not represent the voice of the state in the land acquisition matter. He is in fact stands as an arbiter between the affected landowners and the government. Now, may I please only one decision for this. 2005 volume 7 SCC.
Yes, just.
By 2005 volume 7 SCC, page number.
2005.
My lord, 2005 7 SCC, page number 627.
627.
My lord, relevant para, my lord, may note para 18 to 20. Para 18 to 20, the land acquisition matter. My lord. Para 18. In view of the fact that the action required to be taken by the state government is distinct and different from the action required to be taken by the collector, when the ultimate order is in question, it was for the state to satisfy the court about the validity thereof, and for the said purpose, the counter affidavit filed on behalf of the collector cannot be held to be sufficient compliance with the requirement of the law. The job of the collector in terms of Section 5A would be, over once he submits his report, the land acquisition collector would not know the contents of the proceedings before the state, and therefore he would be incompetent to affirm on affidavit on its behalf. Exactly, madam. Furthermore, the state is required to apply its mind not only on the objection filed by the owner of the land, but also on the report which is submitted by the collector upon making other, and further inquiries, therefore, so as to recommendation made by him in that behalf. The state government may further inquire into the matter if any case is made out, therefore, for arriving its own satisfaction that it is necessary to deprive a citizen of his right to property. It is in that situation the production of records by the state is necessary. My lord, the Supreme Court other decision also quoted. In my petition also, the entire issues not need to be answered by the state government. Collector is trying to cover it, where he has no records over that. So, my lord, the collector affidavit cannot answer, the core issue. And yesterday, with due respect, the learned AG and others, they make a submission, admittedly in absence of the affidavit. And the union up in his affidavit, para 7, 17 and 22, they said that all pillars were removed and new pillars were installed. But did not spell out who removed it, when removed it. And the removal of the boundaries, in fact, it is not the duty of the collector. It is the duty of the state government.
It's just apprising the court, because see, what you have done also in your petition, you have traced history right from East Pakistan days, then right to 2015, where the boundary was finalized. So that question, we're not going to touch or go near that question. The only thing is, again, this court reiterates that what are your rights, that you state you have been violated, or the people you represent, or the other petitioners. That's the only thing. That if there's anything there, as far as boundary fencing is concerned, that will continue, subject to other disputes also remaining. But then we have to see the nature of disputes they've raised, whether they deserve any consideration at all to be other disputes that are still remaining. And view
from the party is that, my lord, the authority comes for measurement. For measurement.
Yes.
They'll cooperate. Okay, let us go for measurement.
But then it's recorded there that you didn't allow them.
My lord, that is one of the they recorded, my lord. In fact, he denied that one.
You instigated all the public.
My lord.
Don't allow survey.
That statement against him is there. In fact, it is not. Now, what they do, my lord, either revenue collector, land records, in NPCC, they go there for a survey, measurement. Then the local people cooperate. Okay, they go there, my lord, and they want to say that they said we need only 15 meters. Okay, 15 meters from where? From the zero line? They said no, 15 meters from 140 yards. Okay, then you have to ascertain where is the pillar. Then they don't know, the officer they don't know. Where is the pillar, permanent pillar? If you don't know the permanent pillar, how can you ascertain 150, 140 yards, 150 yards? So that is the confusion there, briefly. So my humble submission, my lordship may set aside the second notifications and section 19 declarations in the second petition. In lordship may kindly grant the relief prayed for in the secondary petitions, my lord. I prepare a brief of the, I'll submit it, my lord. Submit it. And the third writ petition, my lord, I'm for the respondent.
Yes.
My lord, my colleague is the writ petitioner. I would submit that, my lord. If lordship consider the second writ petition, the third writ petition will also go, my lord.
Follow.
Yes. Lordship, the point or the arguments which have been asked before your lordship are basically twofold, my lord. What I see, my lord. One is that the second notification could not have been issued.
That's simple. That's the only thing. Yes. That's the only ground.
That is the yes, my lord. Now, my lord, kindly examine this aspect from two angles. One, that who are the petitioners and how their rights are getting affected in this matter. Because at least petitioners should show that they have some right to challenge the notification. That is one aspect of the matter, my lord. Second aspect which your lordship may take into consideration is that whether it is causing any prejudice to the petitioner in any manner, my lord.
Yes.
My lord, what was the reason? First, I must disclose to your lordship what was the reason for issuance of the second notification. And the reason, my lord, is that in the previous notification, my lord, the boundary pillar 1294-1296 was missing, my lord. Boundary pillar, my lord. So this was a defective. This was likely the earlier notification was a defective notification. Boundary pillar was missing, my lord. 1294-1296 was missing in the earlier notification, my lord. In the subsequent notification, it has been included. So therefore, that error has been corrected, my lord. If you also will see the judgment cited by my friend, my lord, 1960, paragraph 10, my lord, of that judgment.
Yes.
And paragraph 10, this is 1981 SCC 308, my lord. Paragraph 10, you also have the paragraph 10. The contention was that by cancelling the first notification under section 6, government must be deemed to have withdrawn from the acquisition and cancelled the notification under section 4. Therefore, could not second notification under section 6 without issuing a fresh notification under section 4. You will also kindly mark the factual difference in our case and this case, Lord. Deemed to have withdrawn from the acquisition and cancelled the notification under section 4, therefore could not issue second notification under section. So 4, it was a case of notification under 4 and 6 was issued without issuing a fresh notification under 4. So there was no notification under section 4 and section 6 notification was issued. It was urged that the power of the state government to issue notification under 6 was exhausted and the government could not issue fresh notification under section 6. The court rejected both the contentions observing. Your lordship omit this part and then kindly come to the first notification under section 6 of August 21 was obviously invalid and of no effect. By the issue of this notification, government had effectively exercised power under section 6. In these circumstances, government could well issue a fresh notification under section 6 dated September. So this, in the Honorable Supreme Court judgment also says that government is it is an exercise of power by the government. when there was some error which was found, my lord, that error was corrected and fresh notification was issued, my lord. That is the one aspect of the matter. It is the second, the power of the government is not taken away by issuance of the previous notification. And secondly, if the error has been corrected, no prejudice has been caused to the petitioner by including the boundary pillar which was not there, my lord. That is my first submission, my lord. Second submission, my lord, on if your lordship will see who is the petitioner before your lordship, kindly come to my counter for your lord. Paragraph 9, lord. That with regard to paragraph 9 at page 3, lord. Part 3 of the petition, answering the deponent states that none of the petitioners have enclosed any document evidencing title or ownership of the land in question. However, as per preliminary notification number so and so dated 11th June 2021, issued by the Secretary Revenue and Disaster Management Department, Government of Meghalaya, 5 out of 66 petitioner names are featured in the list persons, namely. So these are the persons who are, my lord, there in the out of 66, my lord. Writ petitioner raises the disputed question of fact, especially related to title of the petition, which cannot be adjudicated by the Supreme Court in writ petition, my lord. Now you also will see what has happened, my lord, after the notification was issued. Paragraph 10, my lord. With regard to government in power, it is respectfully submitted. It appears the petitioners have merely made bold statement that they are the landowners and most of them have land holding certificate issued by the district council in customary land document without actually enclosing documents. On the other hand, respondent Sikh Dorbar Ilaka Satpato through its Dolai has submitted agreement pertaining to cultivation rights. Further, the answering deponent respectively stated since respondent Sikhs have state claim over the land in Muktapur to Pasdwar, while later dated as such a fresh notification was issued so and so, my lord. Now kindly come to, my lord, paragraph 12 at page 7. With regard to government,
yes.
With regard to the government made in Para 8 of the writ petition, it stated that before publication of section 11 notification, a consultative meeting was held on 10 December 2020 at so and so. Even members of the coordination committee of so and so were invited. Notice with regard to survey was issued by letter number dated 11 January and white letter, and the survey was conducted after giving notice in the presence of stakeholders and landowners. It is also relevant that of 66 petitioners, only 5 petitioners had find mentioned in section 11 notification 11 number 1. Now, kindly see paragraph 14. What happened after the notification? Paragraph 14, my lord, page 8. A public hearing was held on 8 November 2021 regarding Sankhat sector BP 1293. MPVP number 129766. However, no land owners filed claim or objection. An undated objection addressed to the Secretary Government of Meghalaya Revenue was received by the Office of Deputy Commissioner on 30th July after expiry of period of 30 days being filed on the period of time. Same was not entertained and this was communicated to Petitioner White dated 5/8/2021. Paragraph, none of the record have been issued to any of the petitioners. So, my lord, the question which calls for a lordship consideration is that we have corrected the notification. We have issued the public hearing was conducted. No objection has been filed, my lord. The petitioner here, my lord, is in my respectful submission is an individual, my lord. What has happened, my lord, that if your lordship will see the amendment which we have raised with regard to locus, paragraph 5. Paragraph 4 of locus also at page 2.
Yes.
He is the only person who has filed the affidavit before his lordship. Paragraph 4. Deponent has not been duly authorized by other 65 persons to file their petition and answer the petition in live. He says that I have been authorized by 65 petitioners to file this petition. There is no supporting the affidavit of the petitioners or the resolution showing that he has been authorized. If your lordship will see the petition only, he is an individual person who is trying to disturb the entire process of, if your lordship will see the government to that effect, my lord, it at page 41 of the petition. He says, I am so and so and I have been authorized by 65, my lord. There is no resolution by those 65 petitioners before your lordship. So my submission is also he has no locus. So first submission was, my lord, that we have corrected the error in the notification. Second submission is, my lord, that he is raising, the petitioner number 1 is raising a technical objection. No prejudice has been caused to him. The land in any case is required to be acquired for border fencing, my lord. The issue is of dispersal of compensation. And Doloi is claiming the ownership of the land. Some of the 5 petitioners are claiming only 5, my lord, who is also not authorized, my lord, are having some document. I'll show the document also. So, but before I go to the my third submission, my lord. First is, my lord, that technical error has been corrected. Secondly, what we are trying to say that hearing was conducted and no prejudice is going to be caused to the petitioners, because ultimately somebody will get the compensation for land to be acquired, my lord. The judgment cited is also distinguishable on facts and both law, my lord. Last but not the least, my lord, if there is a dispute about or who will get the compensation.
Yes, that's important.
Section 77(2), that mechanism can be resorted to, and the deposit can be made. But for that also, my lord, my submission is that there has to be some material before your lordship showing that out of 65 petitioners, they have some document, because they will file a petition saying that and make a bold declaration that I am the owner. My lord, I went through their documents also. If your lordship, I can show from their document which they have filed.
The rejoinder and the rejoinder. Okay.
The rejoinder, my lord, because there is no document, nothing, my lord, and there is no authorization also. But in rejoinder also, I tried to figure out if your lordship will see paragraph 7, paragraph 7, where they refer to the rejoinder with refer to
para 7.
Para 7 of the rejoinder.
Regard of women's with para 9.
Yes, kindly see the last line of this paragraph 7. Instead of mentioning writ petitioner 1, his father name fee foreman is mentioned. Similarly, writ petitioner 7 has not been mentioned wrongly as her shooting instead of her shooting. Further, the name of petition 24 was wrongly mentioned as Lakshmi Lingo, as Lakshmi Lingo. Further, petition 46 is incorrectly mentioned. Besides the landed documents such as sale deed, patta issued by district council, NOC issued by respondent Doloi would go to demonstrate that the petitioners are honored. So what they say, my lord, that sale deeds, patta issued by district council and NOC issued by Doloi are the document on the basis of which they are placing the land. If your lordship will see the document, my lord, one document page 33, my lord.
Of the rejoinder.
Of the rejoinder. Now, with I, GD, paid executive member of the district council, I found that perpetual right to land, including right to buy, sell, trade, sell, deed of so and so. So, one, because what my friend is saying, that CM has issued the patta. Similarly, this is the document which they are claiming, as to the title of the ownership. I have not come across any proper sale deed registration, because the Registration Act is applicable in state of Meghalaya. I didn't see any document where and which land, where do they fall. But we as my lord, I do not want to go into the issue who is the owner, because I have no wherewithal to find out who is the owner, who is not the owner. if your lordship comes to the conclusion, my lord, that this issue requires a leading of evidence adjudication by the authority concerned under relevant section of the Land Acquisition Act, that can be resorted to, my lord. The grievance of the petitioner at best would be that the Loi is not entitled to receive the compensation, for which my friend is already there. He will submit the argument. But the remedy is there, my lord, for which parties can effectively resort to it, my lord. Writ petition may not be a suitable remedy or appropriate alternative efficacious remedy for all these kind of disputes, my lord. The objections with regard to the issuance of notification are highly technical, my lord. The correction has been made, my lord, and it is a project of utmost importance, my lord. In any case, somebody will get the compensation. It will not cause any prejudice to the petitioners. If it is he has a claim, he can seek a reference in accordance with law under the Land Acquisition Act. That is all I have to submit at this point. And third petition, my lord, is again Doloi is asking for compensation. Doloi have approached this honorable court in that saying that they are entitled to receive the compensation. All these matters, my lord, the proper reference can be drawn. We will deposit the money with the concerned authority, my lord, and the process can go on of the demarcation, my lord. That is all I have to submit in respect of all
Yes.
the petitions.
Mr. May, kindly come to page 43 again of the writ petition. Writ petition.
Writ petition.
Writ petition.
That notification.
That notification.
Okay.
Now this notification only pertains to Sankhat village. The boundary pillar is boundary pillar number 1293 to 1297.
Yes.
So it only talks about Sankhat village.
Yes.
Now your lordship, page 87. I'll come to page 100, lordship. Page 100.
Yes.
This is the fresh notification issued by the collector, lordship.
Yes.
Lordship, 101, lordship. My kind says, lordship 100, the first paragraph, lordship. The Government of India Home Affairs is pleased to notify the public that the land measuring about 3,60,845 square meters required at village Muktapur, Laikra, Hawatila, Espitala, Sankhat, Jalaikola and Pasatwar, which falls under jurisdiction of West Khasi district for construction of border fencing from BP 1273 to 1302.
Where reading?
Lordship, page 100 of the notification, first paragraph.
1273?
1273 to 1302.
1273 to
1302.
So you see these boundary pillars are covered. By the second notification.
Lordship. Because in the first notification, those 6 villages were not covered under the notification. So subsequently, the government has rectified that and they have issued a fresh notification whereby not only Sankhat village, but there are other 6 villages also in which the land has to be acquired for construction of the border fencing. So this is the purpose why the government has issued the notification.
All, how many villages is it? All?
7 villages, including Sankhat.
Yes.
So from the pleadings of the writ petition and from the arguments by the petitioner, lordship, the only grievance is with Sankhat village, not with the other 6 villages.
Yes.
Now secondly, lordship,
No, this all comes on the Sar Kapoor Elaka.
Sarpator Elaka, lordship, these 7 villages.
Sorry.
So far as lordship, this acquired land is concerned, lordship, this is a RAD land, lordship, It falls under the jurisdiction of the Ilaka, Darbar Ilaka, Your Lordship. And the petitioners are only cultivators in the said land, Lordship.
They don't have ownership rights.
They do not have ownership rights. And we are saying, Your Lordship, that if they want any compensation, Your Lordship, it should only pertains to the cultivation or the plantation crops, not to the land, Lordship.
So you said Doloi holds the land.
Doloi will hold the lands.
Compensation, whatever is received, will go to Doloi's pocket only.
To the office, Lordship, of the Doloi.
Office, okay.
And so far as the plantation or the cultivation crops is concerned, that will be to the whatever cultivators who are there present in the acquired land, Lordship. So that is the case of the Doloi, Lordship. He's not claiming the entire land, Lordship. He's not claiming any cultivable rights of the petitioners here, Lordship.
Yes.
You know why Lordship, I say that they are only cultivators. And kindly come to page 28 of the counter affidavit filed by the state, or by in the rejoinder, Lordship.
Filed by petitioner.
The petitioner.
So using his own documents against him.
Lordship, when they filed the petition, they had not enclosed any document to substantiate that they are owners, or they are in possession of the acquired land. Subsequently, they had ratified that and they have annexed it in the rejoinder affidavit. Only after the state had filed the affidavit. Lordship, page 28. And these documents are, Lordship, they are manufactured documents. They have been issued by a person who does not have a competent authority to issue the same, Lordship.
But Elvis Kong Yong's terms over.
Lordship, because they requires the NOC from the Doloi, Lordship, to facilitate the
landholding certificate.
Lordship, page 11. Page 11
My
is
submission is that they have only cultivable rights as well.
Lordship. And these documents, Lordship, pertains to sale or agreements with regard to the crops, Lordship, not to the land.
Documents next are incompetent.
Are incompetent, Lordship, because the NOC was not obtained from the competent authority, that is the Doloi.
Yes.
And Lordship, these land documents which now they have annexed in the rejoinder affidavit, these only will show that they are the ownership of the betel nut or any crops which is standing there in the acquired land, Lordship. Which
What is the custom prevalent there?
Custom prevalent there is that, Lordship,
you cultivate only that part you can cultivate, and what happens if you leave it? Is it transferable, intergenerational?
They can sell the property, Lordship. They can sell the adjournment rights, Lordship. That has been done, and these are the seal deeds which have they enclosed, Lordship. And these documents will only show.
It just says the yes.
Page 44, Lordship. Page 44. This pertains to Dhar Khangyong. She's the rightful owner of.
No, coming back to that part regarding only 5 people interested from the entire 66 petitioners here.
Lordship. And
where are the documents of those 5 people?
They have not enclosed, Lordship. I have not come across these documents, Lordship.
Those names are there in the original notification.
In the first notification, Lordship.
Yes.
But so far, Lordship, and another grounds are these 5 petitioners also, Lordship. They are only cultivators, Lordship. They are not landowners.
Whatever it might be, but where is the document?
There are no documents enclosed by them, Lordship.
But in that section 19, section is 11 notification,
then like in
23 of the names are mentioned. not only 5.
No, among the petitioners?
Yes.
No, I'm talking about secondary petition.
The secondary petition.
Only 5 as per the submission of the
But in
application.
reply to that, we have clarified that 23 of the names are mentioned.
Okay.
So we have clarified.
So for Lordship, may kindly come to page 28 of the affidavit filed by the state.
So only one thing, Mr. Nompur, how did you suddenly reverted
Page
for
28.
average from individual landowners or people who are in possession rather? It came to Doloi.
Page 28, Lordship. Can you
Of
come
the-
to page 28 by the affidavit filed by the state? This is a letter dated.
One second. Page
28.
Yes.
This is the letter dated 22nd December.
Reminder.
Lordship. This
Regarding?
is sent way back in 2011. Lordship, this is regarding the land acquisition pertaining to the area involving Muktapur to Jalakola, Lordship. This is the land acquired. Lordship, may kindly come to para 4, Lordship. Para 4. A land compensation should be paid to the Ilaka, and also a standing crop compensation should
This will be looked after by the reference code. So only you go through the see. Yes,
But Lordship,
you
prima
need to-
facie, there's no documents to show that they are the owners of the land. And the stand of the Ilaka is that they are only cultivators, Lordship. There's no dispute over
your
the land
stand is
ownership.
that for the substantial compensation that goes to the Doloi,
The Ilaka,
the
Lordship.
Elaka rather, and for the cultivable rights or whatever crop they lose, they'll go to the cultivators.
To the cultivators, Lordship, who are cultivating in the
a
acquired
portion
land.
in that terms.
Lordship.
So whatever the rights that they have, they assert now also will not be diluted because of the fact that they are cultivating there.
Only cultivators.
And their rights externally to cultivation and the crops.
Lordship.
Okay.
That is the stand of the Doloi.
And not to the ownership of the land.
No, Lordship.
Okay, I just
So that is the
recorded
limited stand of the Doloi, Lordship.
this. So your stand is yes. But the various structures and all there.
There are no structures.
No structures.
No structures.
Okay. Yes, that's it.
That's my assumption.
Short rejoinder, my lord.
Yes, of course.
Only since.
Yes, you have something to say.
Yes.
You are whom? What Simsura has in the picture? Simsura, they have gone into mythology, you know.
That is the only background.
Mythology.
Actually, respondent 7. He's
Yes,
also
what do you have
claimed
to
to
say?
be.
You are? Okay, this is Dalai. Right.
Lordship, with regard to 416, I am respondent number 3 and I have filed my affidavit. And I am relying on the documents for my claim issued by the district council.
Now, no, okay.
Lordship,
You're
that's-
supporting the case of the petitioners?
Lordship.
Or you're against them? Or what is your
Even
right?
I filed the objections
No,
based
what
on
objections to what?
with regard to the claim, Lordship. With regard to fencing and all, I do not have any objections, Lordship. On with regard to compensation.
Claim by the Doloi?
With the board.
Claim to, I mean,
with
you
the
have not filed any separate petition?
No, Lordship.
Then? Were you part of the proceedings before the collector? You
no,
filed your
Lordship.
objections?
No, I have filed objections.
Before the collector?
Lordship.
Saying that they shouldn't acquire the land?
Lordship. With regard to compensation.
If I can submit, Lordship. Lordship, in the other matter, he's a respondent in that matter, Lordship.
Why you mean respondent?
Lordship.
You're the petitioner there also?
Lordship, in item
150 WBC.
in WPC 416, Lordship, I'm the petitioner, Lordship. Now,
What, what do you claim there?
Lordship, the subject matter of that case is that
This is now you're 150, correct?
In 150.
150 first. It's over a year in other petition.
Lordship, I am respondent in both 150.
Yeah, so in 150, what do you have to say?
I have put my claim before
on what
this,
basis?
Based on the historical.
What historical?
I was the based on the relying on the documents issued by the district council, Lordship.
What historical? What claim do you have?
That I am the inheritor of the same Sutna, and that later, Lordship, the executive committee has declared and confirmed that within 6 miles square from Muktapur Old Hart is the ancestral landed property of same, and the income should be paid to the Sutna.
So are they paying any land for the use of land? Are they paying anything to? Exists any office in Sutna now?
I need to get in.
Now, so the thing is that if you're saying the what's that riot rights that you have now, that mean in the some token payment paid to you for use of the land. If you say it's ancestrally, it's vested with this Sutna, so there has to be some connection that the cultivators or the lawyer pays some in this kind of what do you call it, allegiance kind of payment. Anything's there? No.
That I have to get in.
Just saying that how many years ago was Sutna? Yes. Why are you instructing him when a court addressing? That's very bad form.
Sorry.
Don't ever do that. When a court on counsel, you are going over the court and talking to the counsel. Don't do that. You're a young counsel. Don't do that. Yes.
Not sure.
What do you have to say? Let's see affidavit. Since you are joined the party, we have to hear you also.
My claim is on
Where's
based
the
on that,
affidavit?
Lordship. In 416.
You are pro forma.
In 416, Lordship, I am respondent number 3.
So 150.
150. I am respondent number 7, Lordship.
Where is the affidavit? The first affidavit, okay. '59. How we asserted your rights? Is there any recognition of your continuing right over these lands? See,
my claim is still, Lordship, as per the claim, my Lordship, the petitioner can approach the district proper forum where I can put my claim as well, Lordship. And with regard to fencing, I do not have any objection, Lordship. That's my clear instruction.
okay, it's only your ownership claim, that's all. Fine, right. Next, yes, a rejoinder.
My lord, short rejoinder, but I just clarify, my lord. Lordship, may kindly come to page 101A of my rejoinder, my lord. In fact, I am not canvassing the title since Lordship made it clear. But since other two senior counsel, AJ and my colleague has raised this, I just, my lord, draw Lordship attention to page 101A.
101A of the?
My lord, of the rejoinder. This is the sale deeds in fact confirmed and authorized by the chief himself. .101A, madam.
Yes.
But at the bottom, my lord, this sale transaction between such and such and Rio Barre, she's the petitioner number 53. I have once confirmed this land after such and such, the law is about, so that nobody shall have any claim over the land except Rio Barre, who is the owner of the land. This is given by the lawyer himself. And another one, page number 70 of my petition, his own letter is there.
No,
I will not canvass. Yes.
No, rejoinder on law.
Yeah, rejoinder on law, but I'll come to that one, madam. Lordship, may I come to page number 70, yes.
70?
70 of my petition.
Yeah, 70.
Yes. 70, this is the same letter issued by the President Taloy to the collector, to the district council. And what he says, my lord, is very clear. He says, request not to release the NOC for border fencing, my lord. With reference subject cited above, the urgent meeting of the Ilaka Satpada along with the farmers and the village headmen, which was convened on such came to request not to issue the NOC for constructing the such, because the villagers of the Ilaka is yet to understand the boundaries and the line of the fencing, because according to their side, majority of the land will fall outside the fencing. This will be of great loss to the farmers, and for the reason I request not to issue the NOC. He never claimed that I am the landowner. But now on the law points, my lord, the learned HE has pointed out, and my friend also.
Yes, come on, law points.
Yes, that they have issued
the
notification rectified.
So because there was an error.
Yes, my lord.
And so that regarding the boundary pillar which was shifted, and so there's a composite notification as is submitted for all the areas, for all these villages, from pillar so and so to pillar so and so. That's all.
I'll clear it.
Why is that wrong?
Well, why? With great respect, I think my learned friend is yet to appreciate the boundary mentioned there. Lordship, can you come to page number 43?
Of the petition?
Yes, and that boundary is mentioned.
43 again?
Yes, 43.
Yes.
For Suncut, my lord. Boundary pillar is mentioned on the top. 1293 to 1297.
Yes.
This is the boundary.
Yes.
And the same is, my lord, reflected page number 68.
Yes.
They say that there is only one notification for Sangat. There is no others. So they issue a composite one. In Lordship, kindly see page number 68. Separate notification they have issued. Sangat, my lord. Boundary, same thing, my lord. 1293 to 1297. Same boundary, my lord. And remaining one, different notifications are there. So how they claim that there is a composite? No notification earlier, my lord.
See, the thing is that they say from Muktapur to Jarekhola, 1283, that starts from like some other village to 1301 till the end. That means the Sankhat starts from 1293.
Well, like those 7 villages are there. Separate notifications are there. Now this is the first one. The second,
these other notifications exist.
It is very clear. They have. This has collected, mentioned the details. If Lordship summon the record of this nature, separate notifications are available. And now see the, my lord, the rectification they make, according to them. Separate notifications are there.
1 second, 1 second. Just check the. Yes.
My lord, the subsequent notification, if my lord straight away come to 107. What rectification they have made? No rectification, I'll come, my lord. Sankat is available, serial number 4, page 107.
No, but then if it's the same, then there's no apparent change in notification.
Exactly.
So it exists as it is. That means it's only a composite notification
my lord,
with regard to the same area.
My lord is correct.
And how
boundaries are correct?
Because we can understand if, so pillar A, suppose pillar A to pillar B is the first notification, correct? Now, while it's subsisting, the notification, it comes out for pillar A to pillar C. Then we can see there's a substantial change, and so you cannot have issued the second notification without, and whether this is a composite notification, because if the same pillars you're not affected, you want to your case is for pillar 1293 to 1297.
But my
4 pillars. So your 4 pillars remains.
Right. So, it remains. It remains. My name is there. Now I don't dispute with the pillars.
No, we're not going to go there.
They removed the
we will
petitioners.
record that in the first notification, the names of certain people have been given as owners between these 4 pillars, right? Yes. But the thing, the subsequent notification has shown Daloy. That'll be subject to reference court as facts. We're not going to go to. We're not settling ownership here. We're just setting the procedure which adopted by the state respondents or by the union government, whether it's correct procedure as per the act. And if we see that there's no serious irregularity in the procedure, then there's no cause for interference. Everything can go on. That's all.
Boundaries are remain the same.
Now, then there's nothing to defend this case.
But the grievance is that, my lord, if the boundaries are same, what is the requirement of issuing a second notification? Because of the claim of the ones
because where is amount to a rarity that that totally disabled the entire notification. Yes, if it amounts to that suddenly the boundaries have been changed. And so when this name of this person shown the first notification for a certain boundary pillars, they're shown as such, and the second notification, the dollar has been shown as the owner. Then there might be some cause, maybe the second notification is defective. But then the thing is that in this case now, by what you have just enlightened the court, is that there's the same boundaries. Only that in the earlier case, A, B, C, D names have been shown, and second one, the dollar said he received the compensation. So that will be stopped in the intervening period. And those people who are named in the notification can go before the under section.
Yes, 62 and 74.
Whatever, yes.
They can go, my lord. Only, my lord, the humble submission is that therefore issuance of second notification is not arise. There is no requirement.
No, it becomes redundant. It doesn't matter.
My lord, here, my lord, in one plot of land, one plot of land, there cannot be two notifications.
The entire process is redundant.
My lord, my humble submission is last, my lord. For single plot of land, plot number 1, there cannot be two notifications. That is my humble contention.
We'll record your submissions, but we will record it in the light of whether it will, defeat the entire purpose of acquisition. That this, which is an apparent error, which is against the, the set procedure, whether it will, disable the entire process. That's all.
So even if lordship set aside the second notification, that will not prevent them to resort to that form.
It have no effect. Because the second notification just reaffirm the same boundary pillars. We are thankful that you showed that. The score of thinking that is totally, it's come from, like a reverse kind of situation. Yes.
Lordship, just one more submission. The entire dispute or entire claim of the petitioner is pertaining only to Sankhat village, not to the other villages.
Right. Not that we noted.
Only Sankhat village.
Yes. Yes. Next matter.
The second petition.
Lordship, in the second.
The third matter, right?
Third matter.
Yes.
That matter may not be only with regard to who will receive the compensation.
Yes.
So the issue is that can be.
This is the notification number?
416.
No, because these matters have been hanging unnecessarily before the court with substitution and affidavits.
Quite some time. Yes,
yes.
I should page 70.
You're the petitioner here.
I'm the petitioner. Page 70 of the petition.
Does not mix up the things. Page
70.
70.
70.
Yes.
So this is that same notification which Leonard Senior has challenged in the other petition, whereby the office of the Doloi has been named as the landowner.
Yes, 30 yes. What is your prayer here?
My Lordship, may kindly come to page 85.
What is the letter proceeding date 22/11?
Page 85 is the impugned letter, Lordship. Page 85.
Yes. What is this?
May be allowed to read, Lordship.
Yes.
The chairperson welcome all who are present in the meeting, and the matter discussed as follows.
Public hearing.
It's public hearing, Lordship. 1. The process of land acquisition for the concerned stretch was completed in the name of the Doloiship of Ilaka Sapator. The process has now reached the award stage. The office of the Deputy Commissioner received objection from two parties, namely Shri Arvind Sutna and Shri Bastar Salahe. A. The parties were briefed and they are furnished the relevant documents, which will be sent to the Special Judicial Officer. The chairperson also intimated to the objecting parties that this particular matter of dispute is outside jurisdiction of District Administration. 4. The chairperson informed the parties that the Deputy Commissioner may take advance possession of the concerned stretch forward to proceed. 5. Both parties requested a period of 1 month to reach an agreement. Actually, we were aggrieved by this condition 5.
With regard to?
Condition 5.
Both parties meaning whom?
The Ilaka,
Doloi and you?
The Doloi and Mr. Arvind Sutna.
You asked for time to...
No, Your Lordship. No, Your Lordship. Since we are relying on that notification, Lordship, the collector has identified as the landowner. There's no question for us to go and settle with somebody, Your Lordship. Now, this person, Lordship, the respondent number 3, has filed one objection, Your Lordship, before the collector at page 69. Now, he comes forward and claims compensation, Lordship. Page 69 is the objection filed by him, Lordship.
You also have a piece of the pie.
Lordship.
Page
69.
Yes.
Now this objection is 27/9/2022.
Yeah.
Now he simply files one page objection, Your Lordship, with an intent to stall the compensation and to deprive the landowners from receiving the compensation, Your Lordship. While filing this objection, he has not enclosed any material document to show that he is the landowner, Lordship.
No, Nathan, the other thing, affidavit does not enclose anything.
Lordship. So in this scenario, Lordship, the claim of the respondent number 3 cannot be accepted. There is no prima facie case established by him to say that he is in possession of the acquired land and he has some share in the compensation, Lordship.
Just wants a share of the compensation. He doesn't care what land on the thing.
Lordship, to have a share, Lordship, he has to show some prima facie
the
case.
same things, IBVF cases, the others also where in the final stage of disbursement of compensation, some people come forward and say that, this part is mine, this part is mine, just to stall entire disbursal process.
But can this be accepted, Lordship? Somebody might come and just say that I'm the owner, Lordship, without any enclosing any land document. And he represents himself as the same of some same Sutnga clan, Lordship.
He represents the same Sutnga.
That he's the king of Sutnga clan, Lordship.
He claims he's the king.
Lordship.
Or the chief.
The chief.
Yes. Where's this affidavit?
Lordship, he has filed an affidavit.
Oh, this one, yes. He's gone. Okay. Lord Benting, page 14.
Lordship. Page 14, Lordship.
No, because after, see, what happened in Janta Hills was that it is like actually annexed territory, not like in Khasi Hills where semi-independent chiefs were allowed to continue administration. In Janta Hills, it's a complete annexation. That's why the Dolois were there. That's all. Otherwise, just to maintain that, it is other.
Then there should not be any Doloi, Lordship. There should be same.
No. Dolois are there.
Lordship. But as per the claim of the respondent 3, Lordship.
If it was not annexed, then there would still be maybe CMs that existed.
Lordship. Now these documents will not show that he's the owner of the acquired land, Lordship.
Becomes more in the what do you call it, as a part of lost fables. Yes.
Lordship, so far as the Ilaka.
Mr. Palay presenting that, what do you have to say? Where's he gone? This is filed by you. You are representing this point number 3. Yes? Yes. What do you have to say? Since it's directed only against him only. Respondent 3 only. Yes.
As per the office of the Doloi Ilaka, Lordship, I am the office of the Doloi Ilaka, annexure 3 of my affidavit. Page 23 is translated copy. It's page 25 and 26, Lordship. Para 8, which confirms that I hereby confirm that Sri Erving K. Sutna
See, the thing
has
is
the
that
right.
now, what happened? This is already what you call a lineage that is extinguished also. in 1835, correct? Who was your last king?
We are, Lordship, we are
when the British came and annexed that territory, who was the last Raja? Not King Raja. Are you aware of the history? You argue such matters, you should have the entire history in your fingertips as to what is, what is the entire history of Jainta Hills annexation, the Jainta Wars and everything. Are you aware of that? You have not been briefed?
No, Lordship.
No.
Lordship, I was instructed, Lordship, that since it's an ancestral property of this.
See, there can't be such a simplistic kind of argument.
Lordship, and I am ready
if
to
you want a court to accept arguments or say that maybe you have any sort of a enforceable right,
Lordship,
then you have to show by cogent materials, whatever, that my right stems from this historically, is still recognized till date. I might not be like sitting Raja anymore, but by virtue of whatever pre-independence, pre-constitutional, pre-British, that I have surviving rights. Doesn't mean that it's just like, was that Khan Bahadur Zafar Khan's who was that who's claiming maybe the Taj Mahal or something?
Yes.
It amounts to that. Who says that, okay, that property restore my palace after the last Mughal was taken to Rangoon. So you want the petition to be, then you want to be, then you have to file a petition like restore my properties, that's been taken over by the British. Last Raja the kingdom was taken over in 1835 with the British. The last surviving Raja at that time was recognized. Then you go for media blitz to show that, show your coronation, that you're the king and you want to, take back your kingdom. You can't come like this by just saying ancestral rights should be respected. You can't expect the collector to go into inquiry and read history. Yes.
I have some more submissions, Lordship.
Yes.
Kindly come to page 34. Because the office of the Ilaka has once upon a time also received compensation from the government, Lordship. So far as that stretch is concerned.
In
my red petition.
Okay, page 34. Okay, yes, we'll close the high hearing now. Yes. Since I'm short of private secretaries, I'll have to reserve the judgment. Yes.
Obliged.
Lord, boundary fencing can go on, Lord.
Of course. That's a given. We have to hear the entire parties as what the exact grievance is.
Yes, Lord. So, Lord, may permit us to carry out the boundary.
I have already filed my affidavit also in the last writ petition. I have already filed my affidavit.
Lord, I am not in India. They are doing this.
Oh, where are you in the US? Oh, so it's just 5 hours ahead, behind, so it doesn't matter.
Behind me, Lord. 6 a.m. 6 a.m. in the morning.
Yes. 6 a.m. Can go for your jog now, yes. Yes.
Daily list, item 19.
May it please, Your Lordship.
Who's appearing for respondent?
My Lord.
I'll be representing respondent number 1 to 5, Lord.
1 to 5 is?
The state respondents, my Lord.
You are a state council?
Yes, my Lord, I am the standing counsel of the state of Meghalaya and Supreme Court and NGT, my Lord. I have been under sections of the learned AG to appear in this matter.
Yes, we'll take it up then at 2:15.
Yes, my Lord. As Your Lordship, please, my Lord.
Yes. 2:15. Yes, other matters?
22.
2:15. Yes.
Obliged, my Lord.
When a hearing concluded, this will reserve.
I know this last item number 29. Can you come up after 1 week?
22 is called.
Oh, sorry.
Lordship, in this matter, I am bringing some more accommodation, Lordship.
Why are you bringing for accommodation?
Because
you ready with the matter?
No, they have informed in the morning itself that they will not start.
Okay, after 2 weeks, yes.
much obliged, Lordship.
24. 24.
Second half, Lordship. I'm ready, Lordship.
24, we'll take the other matter. Second half, only one matter. We'll take up the other matter. A fixed matter.
Monday, Lordship. Next Monday.
What's the matter about?
It's promotion matter, Your Lordship.
That same thing, ECR.
ECR.
Communicated.
Communicated. I'm against the speaking order, Lordship. Your Lordship had heard on Friday. Monday, Lordship. No pledge.
You're retiring soon?
No,
You're already
Lordship.
retired?
No, Lordship.
Make sure, but yesterday, Mr. Pathak's matter, he was on promotion when we saw that he's supposed to have superannuated in last year already.
Though he's granted promotion, but we are seeking retrospective promotion, Lordship.
Yes.
27. 27.
Yes.
My lord, this matter can be disposed of, my lord. We have forwarded the names also for the interest on the gratuity, my lord. So as soon as we get, we'll pay to them.
Yes. Where's Mr. Khan?
Your Lordship, due to some personal difficulty, he had to leave. So, Your Lordship, if
But
the
you
matter
pick up the
can
children
be.
from school. Yes. Tomorrow.
Tomorrow.
Yes.
Not tomorrow, day after then, my lord.
Day after tomorrow.
My lord. Obliged.
Obliged, Your Lordship.
29.
Your Lordship, this matter will come up after 1 week, Your Lordship.
Why you got some paper to show?
No, my lord. My lord, in fact, I've already mentioned that her pension is being under process.
We'll close it, Mr. Khan.
This can come in a short period of time, my lord.
We'll give a direction within time frame.
But the thing is that, Your Lordship, in my grievance in this case is that there's been tampering in the
bird.
Yes, bird.
And the school has not been made a party, my lord. Interestingly, the document who have issued, they have not been made a
But
party.
the day, this after it, just
After 1 week, Lordship. After 1 week. Yes. Highly obliged.
I thought there was some other hearing matter is.
May it please, Your Lordship. May I have Your Lordship permission to just give a quick recap of the background, if I may be allowed, my Lord?
Yes, only one thing.
Yes,
we have only 45 minutes because I have a schedule, another thing at 3 o'clock. Anyway, yes.
Yes, my Lord.
Yes.
So, my Lord, the basic grievance of the petitioner is basically twofold. First, my Lord, the being an employee of the state government, she joined her career in the Meghalaya State Tourism Corporation, MTDC, in the year way back in the year 1993 by following the due process of law, my Lord. And then she continued to serve in MTDC for 17 years. In 2011, she was basically brought on, my Lord, deputation before the office of the Comptroller of Household, that is in the Governor's House, my Lord.
2011?
2011, my Lord. On, my Lord, deputation for 3 years. Then she was permanently absorbed in the year 2014 in the Governor's office, my Lord, as a Comptroller of.
Yes.
So from 2014 onwards, she has been serving even till date as a, my Lord, Comptroller of Household in the Governor's place, my Lord. Now, she has been serving for more than 30 years now today, my Lord. Now, the basic grievance of the petitioner is that now for a person like petitioner or other similarly situated persons whose work involves, my Lord, 24/7, my Lord, they will have to give in Governor's residence, my Lord. And apart from that, even in MTDC also, there was no scope for any promotion for the post that she was serving. So there was a scheme which was introduced by the Fourth Pay Commission, my Lord, wherein this scheme named, my Lord, as Assured Career Progression Scheme was introduced for those employees who has stagnancy or stagnation in their career, just to boost their morale and just to help them to grow in their post, my Lord. Now this was introduced way back by the Fourth Pay Commission in the year 2011, and MTDC authorities, they adopted in the month of July, perhaps more particularly on the 7th of July 2011. And my last serving date in MTDC was 8th of August or on 9th of August, my Lord. I'll come to that point. So when I left MTDC, the scheme was very much in force, my Lord.
In MTDC July.
So,
and you said you left in 2011 itself.
Yes, in the same year.
MTDC on?
In the month of 2011, in the month of August, my Lord.
So the scheme have been put into place.
The scheme was put into place. In fact, the state government had adopted the scheme much earlier than to the month of July. But for the sake of argument, my Lord, the MTDC, they have adopted in 2011 on the month of July, my Lord. So I was very much working under MTDC. So the law that was prevailing at that point of time was clearly applicable to the case of the current petitioner. So however, my Lord, now what happened in the year 2011, when I left, I have almost completed 17 years of my service. From 1993 onwards, my Lord. Then, my Lord, in 2014, when I was absorbed there, in between, my Lord, the new scheme came into being. It's called Modified Career Assured Progression Scheme, my Lord. They brought some modification, and now I've even become eligible to be, my Lord, benefited by this particular scheme as well, my Lord. Now, I have been pursuing this matter before the authorities that you give me these benefits, because now, since, my Lord, 1993, I have not been given by filing various representations, my Lord. This is one fold of my Lord, argument pertaining to my claim. There's another fold, my Lord, which is, my Lord, relating to financial upgradation, which I have made a claim before the state authorities for upgrading my financial, my Lord, scale from level 16 to level 18, my Lord, which is also before this honorable court, my Lord, the claim of the petitioner. And that particular financial upgradation has, sorry, my Lord, that particular financial upgradation has also been similarly rejected, saying that you are not entitled. And the entire matter of, my Lord, this financial upgradation to level 18 is a matter of policy of the government, because what I am claiming is that my post as a Comptroller General in the Governor's office is equivalent to the post of a Joint Secretary, and in most of the northeastern state, the post of Comptroller General is equivalent to Joint Secretary. So my claim was based on that aspect, that I should, and further, my Lord, that the Governor, Honorable Governor himself has approved my petition, my application, and had forwarded before the government to basically take a call on the approval of the Honorable Governor, my lord, but they rejected it. So that is another fold of my lord, case before your lordship, my lord. So insofar as the first leg of my argument is concerned, my lord, the MTDC has...
Now, only thing, it boils down to what are your qualifying years of service?
Yes, my lord.
To avail of your ACP and that's
yes,
it.
my qualifying
So
years
how
of...
much you served in what,
yes, my
that
lord.
MTDC?
Yes, my lord.
And you're coming over to the Raj Bhavan?
Yes, my
so
lord.
like cumulative or
period of my service, correct, my lord.
That is the
basic issue before lordship. And I have just made a bullet points of my for your lordship convenience. I'll just like to place one for my learned friend also. So, just a background to just help your lordship to know my period of services in MDDC as well as government.
Yes.
Now, if I may, then should I continue with my argument, my lord? Or yes, my lord. So, my lord, here, in this case, my lord, just quickly, I would like to take your lordship to the rejection letter, which was communicated to me by MTDC, my lord. That is relevant at page 107 of the writ petition, in which case MTDC had rejected my case, my lord. Just
19/12/22.
Page, my lord, this letter is dated 19 December 2022, my lord. May I just read, my lord?
Yes.
Now, with reference to the above mentioned below detailed information as per your personal file maintained in NPDC, appointed as room service order taker with effect from 8/8/1990 on ad hoc basis. I am not even taking this part into count, my lord, for counting my regular service. Appointed as management trainee with effect from 1/5/1991 for 2 years on contractual basis, my lord, at the pay of 1,400 per month. Point number 3 is very important, my lord, because from here I have started to count my regular services.
1/5/93.
Yes, my lord. This is very important. Appointed permanently as supervisor from 1/5/1993 with a pay scale of rupees such and such till such and such. Appointed as assistant manager and posted as in charge hotel operations head office MTDC against advertisement memo number such and such dated 1/2/2010 against pay scale of such and such, my lord. Now here, just want to point out one thing, my lord. This appointment as assistant manager, the scale that I was drawing earlier as supervisor was lower. So there, I'll take your lordship to one letter issued by the MTDC, wherein they have enhanced, in order to bring me at par with my earlier pay scale, they have given a notional increment of rupees 460, my lord, just to bring me at par with the post of my assistant manager. Because as a post of supervisor, I was carrying more. My earlier post in MTDC, my pay scale and my basic pay was more than the new post to which I was recruited subsequently.
The new post meaning to?
That assistant manager, my lord. Point number?
The scale is lower.
Scale was lower, my lord.
How is that possible?
That is exactly, my lord. So they, in order to make me at par, they invoke, my lord, fundamental rules and supplementary rules. There's a provision wherein, in order to keep the employee at par with the earlier basic pay, whatever he was doing, so an increment, a notional increment was given to me, my lord. So there was a provision, so they have invoked that, my lord. I'll come to that little later, my lord. Then your lordship will come to point number 5. You were on deputation as Comptroller of Household in Raj Bhavan for a period of 3 years, starting from 8/8/2011. This date is again important, my lord. Thereafter, my lord, you were permanently absorbed as Comptroller in Raj Bhavan with effect from 8/2014, and subsequently name was struck off from MTDC staff strength. Now, this is important, my lord. In view of the above, your total service in MTDC is 21 years, my lord. So it is undisputed.
93 to
till, my lord,
2011.
This August 2011, when I was on deputation, my lord. It is 8/8/2011, my lord. Now, in view of the above, your total service in MTDC is 21 years, 3 months and 7 days, which includes your 3 years deputation period in Raj Bhavan. Then, my lord, may turn to the next page, my lord. Further, MTDC had adopted ACP rules. This is Assured Career Progression Scheme I was referring to, as per board's approval on 5/7. This date is very important. So I left the MTDC on 8th of August 2011. Your lordship has seen it, point number 5. Then they adopted it on 5th of July 2011, which was prior to my leaving of MTDC, my lord. Then, my lord, held in 127 board meeting, which was introduced by Meghalaya 4th Pay Revision by memo number such and such dated 22nd February 2010 and was implemented by MTDC with effect from 7/7/2011. So this is the date of their application of this scheme. This is very important why they have rejected my case. Therefore, as per Meghalaya Pay Revision, 4th Pay Revision Memo number such and such dated 24/8/2010, Clause 3 of Annexure, if there is an upgradation of scale before the date of implementation of the scheme, ACP becomes due on completion of 24 years of services. Copy of the such and such dated 22/10/2010 and FR number such and such 24/8/2010 enclosed for your information and perusal, please. Since you have not completed 24 years of services in MTDC, therefore you are not eligible for ACP as far as your service is concerned with MTDC. Now this financial notificates, Meghalaya Finance Pay Revision Notification of 2010 Clause 3, they say if I have been upgraded prior to the implementation of a scheme. Now, in their affidavit has elaborated what was my financial upgradation. So, if I quickly take, my lord, rather than going into it, to the affidavit of MTDC, my lord. Affidavit filed by MTDC, my lord, may kindly have, my lord. Respondent number 6, my lord. I'll only take your lordship to the relevant paragraph, my lord. Paragraph number 9 is important, my lord. May I read, my lord?
Number
9, my lord. At page 3 of the affidavit filed by respondent number 6, MTDC, my lord.
Yes, para 9.
Para 9, my lord. May I read, my lord? Yes. That in reply to the statements made in para 5, the answering respondent states that while the petitioner was serving in the post of supervisor, the last pay scale at such post was 14,000 to 27,510. Have your lordship found? And the last pay drawn was 20,230. Thereafter, petitioner participated in direct recruitment to the post of assistant manager, which was advertised. On being successful, petitioner was appointed to the post of assistant manager by the appointment later dated 15/11/2010. Consequent upon appointment of petitioner to the post of assistant manager, her salary was fixed in terms of, lordship we see, FR 23(1) of Meghalaya FR and SR 1984, where the petitioner's pay of scale was 17,000 to 33,000. That is earlier as supervisor, and the basic pay was fixed with notional increment of rupees 20,850. They have given the calculation. 20,900 plus 560 is the notional increment, 20,850 upon being granted financial upgradation in the form of notional increment, my lord. So they construe this 560 rupees as a financial upgradation.
For now, you say that just to balance the from whatever you were trying earlier, supervisor, which was higher. So they made it to make it equal.
Make it equal, my lord. Now, my lord, the next paragraph, if your lordship reads, my lord, just quickly I'll read the next paragraph. In this regard, it is stated that clause 3 of the Meghalaya Pay Revision, 4th Pay Revision Memo number such and such dated 24/8/2010 provides that if there is an upgradation of scale before the date of implementation of the scheme, ACP becomes due on completion of 24 years of service. Therefore, to qualify for ACP benefits, the petitioner would have to render 24 years of service, continuous service with Meghalaya Tourism till 1/5/2017. Petitioner has not completed.
So you see that since you have upgraded in 2010, scheme came 11, so you already have avail of the upgradation, which would have come with ACP.
I will not come under ACP according to
I mean that should have come, you already availed of it.
Yes.
It amounts to that, yes. Okay.
Now, if I may take the FR just for a quick reference.
Yes, of course. Take your time, no problem.
Yes, ma'am.
People are buying.
There is a chapter called Part 3, Chapter 4. Yes, madam.
That is?
There is a chapter, my lord, Chapter 4, Part 3, and there is another heading called Time Scale. Under Time Scale, there is FR 22, then FR 23.
Part 3, Chapter 4, Pay.
Yeah, pay, my lord. Then lordship will then come to the next heading, that is time scale. There is a chapter called time scale also, if under FR 22. Have my lords found?
Yes.
Then 23 is the relevant provision, my lord.
Yes.
If I may just read, my lord.
Yes.
The initial pay of a government servant who is appointed to a post on time scale of pay is regulated as below. Where a government servant holding a post in a substantive, temporary or officiating capacity is promoted or appointed, the word is appointed also, my lord, in a substantive, temporary or officiating capacity to another post, carrying duties and responsibilities of greater importance than those attaching to the post held by him, his initial pay in the time scale of the higher post shall be fixed at the stage next above the pay notionally arrived at by increasing his pay in respect of the lower post by one increment at the stage at which such pay has accrued, my lord. Earlier post was not at par with the new appointment, so to bring the parity, this they have invoked. So it is
notional increment.
This is a notional
upgradation.
Increment, my lord. Now, if I may take my lord to the scheme, assured career progression scheme, my lord.
Yes.
That your lordship will have to again. I'm sorry, my lord. Take the writ petition, my lord. Which I have annexed it as annexure 11 at page 65, my lord, of my writ petition, 65.
Yes.
My lord, this is published on 22nd of February 2010 by the Meghalaya government, my lord. May I just read, my lord?
Yes.
Office Memorandum, Assured Career Progression Scheme, ACP for State Government Employees, my lord. The 4th Meghalaya Pay Commission in para 10.3 of its report has recommended introduction of a new scheme to deal with the problem of genuine stagnations and hardship faced by state government employees. The term they have used, my lord, state government employees. Due to lack of adequate promotional avenues, especially those belonging to services or holding posts generally classified as common categories and isolated posts, as per the recommendations, career progression benefits will be available to a government employee who stagnate in service for a continuous and specified period of time in the form of financial upgradations to be allowed twice in his service career subject to fulfillment of certain conditions. Government has considered the recommendations of the pay commissions vis-a-vis the governments of India's existing scheme of this nature and has accepted the same. In pursuance thereof, the undersigned is directed to say that the Governor of Meghalaya is pleased to order introduction of the scheme under the title and guidelines as specified below. Number 1, the scheme shall be known as such and such, my lord. The benefits of the scheme shall be available to all posts in such and such groups, my lord. Then your lordship will kindly come to page, my lord, next page, the relevant part I'll be just reading. My lord, they, in order to give effect, a committee or screening committee needs to be constituted that your lordship would find from column clause number 6, 7 and 8. I'll not read it. How to basically deal with these applications for, my lord, career assured progression scheme. Then lordship will, I'll skip that and come to point number 4, my lord. Point number 4 says the assured career progression scheme shall become operational from the date of issue of this office memorandum. Otherwise also the state government has given this direction. It will be operative from this particular date, my lord. Now, my lord, what are the terms and conditions? My lord may kindly come to page 68. Conditions required to be eligible under the scheme. At page 68. May I read the first condition, my lord? Yes. There shall be 2 financial upgradations under the scheme counted from the direct entry of a government employee. This is very important. Into regular service on completion of 12 years and 24 years services respectively. The first financial upgradation shall be allowed in the next higher scale of pay after an employee has completed 12 years regular service in a scale of pay, and second upgradation after 12 years of regular service from the date of the first financial upgradation. If the first financial upgradation gets postponed due to reasons that employee is found unfit or due to departmental proceedings, it shall have consequential effect, and the second upgradation will also get deferred accordingly. Lordship may skip point number 2. 3 is important. Counting of regular services for the purpose of ACP scheme shall commence from the date of joining of a post, my lord. This is very important. Date of joining of post. In my case, 1993. In direct entry grade on a regular basis, either on direct recruitment basis, so there was an advertisement, there was a due process followed, or on absorption or re-employment basis. Services rendered on an ad hoc regulation 3F contract basis before regular appointment or pre-appointment training probation shall not be taken into reckoning. However, past continuous service in another department, this is very important, my lord, of the government of Meghalaya in a post carrying identical scale of pay prior to regular appointment through proper channel in a new department without break shall also be counted towards qualifying regular service for the purpose of this scheme only and not for regular promotions. Now this second proviso, my lord, is very important because this will have a meaning on the next two clauses, my lord, because state government, I just did not indicate, your lordship, also has taken a stand why I am not eligible, because state government has a very categorical stand in the affidavit that I do not fall under the purview of this scheme, so they have not entered in my case, my lord, under ACP. And why? Because of this clause of 5, my lord. I'll read, my lord. Just kindly, lordship may take clause number 4, my lord. Regular service in the past shall include all periods spent on deputation, foreign service, officiating in a higher post, study leave, and all other kinds of leave duty sanctioned by the competent authority. This 5 point is what they are harping upon, state government. Past service rendered by an employee in another state government, stroke statutory body, stroke autonomous body, stroke public sector organization before appointment in any department of the government of Meghalaya shall not be counted towards regular services. So what they say, my service in MTDC was, according to them, is a service rendered under different state government. So I am not entitled under this clause to be benefited by this scheme, my lord. So these are the credentials, sorry, my lord, these are the, I mean to say, my lord, the my lord, terms and conditions required for my lord to be benefited by the scheme, my lord. Now, my lord, may I skip this part. Now, in 2000, in page number 76, my lord, if your lordship comes, on 19th of December 2017, they have modified the career progression scheme and had introduced modified career progression scheme MSCP for state government employees, my lord. Here also, my lord, some small changes they have made. Otherwise, the idea and the objectives are same, my lord. And here they have changed my tenure. Earlier it was 12 years and 20 years. Now they have 10 years, 20 years and 30 years of services under this modified scheme. However, under this scheme, I was already under state government in order to be eligible under this scheme. So in order to give a retrospective effect to the terms of the earlier scheme would be applicable in my case, because in MTDC, the assured career progression scheme was prevalent at that time, my lord. So here, this scheme will govern only to take care of my part. If at all they want to bifurcate my case into two different categories, although I am not arguing on that, my lord, because it is one entity for me, for completing my whole service under the government of Meghalaya, my lord. So I will not take much time reading these schemes, my lord. Only at page 81, the points that they have introduced here, just I will quickly read, my lord, what is regular service means and counting of past service means. Just I will read at page 81, point number 24. Regular service in a post shall include all periods spent on deputation, foreign service, officiating in a higher post, study leave, and all other kinds leave sanctioned by competent authority, etc. Counting of regular service for the purpose of MACP shall commence from the date of joining of a post in direct entry post on a regular basis, either on direct recruitment or on absorption. So here also, if they have to count my 1993 services, they can still count under this particular provision. 26, my lord, the term entry shall be defined as the post to which an employee is initially appointed in government service by direct recruitment by the competent authority. Then, my lord, 27, an employee who has been initially appointed in a post in one department but gets substantially appointed by direct recruitment through Public Service Commission or by other authorized means in another post carrying a higher pay scale or same pay level in the same or another department will be eligible. Here also they have gone extra mile in taking cases of those people also who were in different department, which can squarely cover my case as well from this particular provision, my lord.
But that's not there earlier on.
but which was not there earlier on, my lord. Correct, my lord. The case of an employee who gets their prior services in the entry post in the former department carrying the same level of pay of the later department will also be reckoned, my lord, for qualifying services for replacement under the MSCP scheme. So these are the provisions which basically can be made applicable to the case of the current petitioner, my lord. Now, my lord, at page 82, just one line I will read, my lord. This modified career age assured progression scheme shall be deemed to have come into effect from 1st January 2017, my lord. Then subsequently, my lord, thereafter I have been writing representations, my lord, submitting, my lord, before the authorities. They have been kind enough to, my lord, respond to some of them, and I have just pointed out, my lord, that how they have rejected my case. Then there was another aspect involved which I have submitted in the initial stage of my argument, my lord, that I was also praying that there has to, that they need to make an upgradation of my pay scale from level 16 to level 18, my lord, which they have rejected by an order which your lordship will find at page 103, which is also impugned in the current proceeding. So that part, my lord, maybe I may not be pressing much, because I can see from these minimum records, my lord, whatever has been submitted, and from the affidavit, that it is a matter indeed of a policy matter of the state government to make a post to a higher level from level 16 to 18, because these things, as a petitioner, as a person, my lord, we cannot claim as a matter of right, my lord. Of course, that cannot be. So in that case also, my lord, perhaps that part of the argument I will not press much, my lord, on this, because the order at page 103 clearly says, my lord, if I may just read, my lord, sanctions of for upgradation of the post of controller of household at Rajbhavan from level 15 to level 16. So it says, I am directed to refer to this department letter dated 4/8/2021 and to state that effective date of upgradation to the post of controller of household from level 15 to level 16, which is personal to Anamika Datta, will be effective from 4/8/2021. With regards to upgradation up to level 18, this department regrets its inability to agree, my lord. So from 18, whatever I was submitting, even my prayer is still pending before them. If they still feel that, that they may upgrade it to level 18, then of course, my lord, they can still go ahead, my lord. So this is my humble submission, my lord. We are here only on the aspect of whatever, my lord, representations we have submitted and the order passed by the authorities at MTDC that my case is not covered, I mean, to under the scheme for considering me under ACP or MSCP. So that part we are basically prejudiced, my lord. So
no, one thing is that whether, you know, the upgradation given to the notional increment, can it be considered upgradation?
That is one aspect, because what
that is the only question.
Yes, my lord.
It's not upgradations, only to bring about a parity.
Parity, correct.
That's what within the post that you served earlier. So then,
in fact, they have themselves admitted in the affidavit that it is a notional increment in the form of financial, my lord, upgradation. So in the form of the term which they use for their convenience, they have used it in the affidavit. Otherwise,
so the paying for MTDC and for the state.
My lord, Mr. Mani Tripathi is on the moment. He'll be arguing for the state.
I'm obliged, my lord.
Yes, Mr. Tripathi.
Yes, my lords, as I understand from the argument of my learned friend today, that his principal grievance is regarding his her ACP from MTDC and not from the state government. And in the alternative, I think, as I understand from the pleadings, that after the MTDC has rejected his claim for ACP, then a representation is made to the state government to grant the same, that if they are not granting it, you grant it. And reliance is being made upon the ACP and MSCP schemes, my lords. My lords, here the dates are, almost all the dates are admitted, that the services of the petitioner with MTDC commenced with effect from 24/6/1993 as a supervisor, fresh appointment. Before that, she was working as a contractual employee. That is the period is not in question. From 1993, June 1993 till her absorption in Rajbhavan on 26/11/2014, she was on the rolls of MTDC, working as an employee of the MTDC. Yes. Now, the point which is being canvassed by my learned friend is that she was working in the state government, which is completely baseless, my lords. MTDC, my lords, is a company, though a PSU, but it's a company. The state government has no role to play whatsoever, either in sanctioning of posts of employees of MTDC, either in recruitment process, laying down eligibilities, or their service conditions, etc. The state government has no role to play at all in controlling the employees of MTDC. They are solely their employees, and I'll place a judgment of the Honorable Supreme Court, just one. There are many. I'll place one at the end of my arguments, my lords, to show that even if 100% funding is going from the government to a public sector undertaking, the employees will never be considered as an employee of the state government or a state department. The departments have their own procedure. They are bound by the rules and regulations framed for the state government per se, and the rules of business for different state governments are provided, which is not applicable on any corporations. So whatever services the petitioner has undergone with MTDC is clearly debarred under the ACP scheme. I'll read that clause again, my lords. For being considered as an employee of the state government, it is what is permissible is only transfer, interdepartmental transfer, or a fresh recruitment from on a fresh post within the government. Suppose a person is working on an X post in another department, and through proper channels applies for a fresh recruitment, and get the previous service should be counted for that. Then, Your Lordship, the ACP scheme, if I may take Your Lordship the same clause again and read it at the ACP schemes start at page 50, relevant portion at 52 words. I'm sorry, it's page 65 at 68, at 68.
Yes.
At 68, my lords. My learned friend has read the whole clause, but I'll seek your lordship's permission to read it again. Clause 3, my lords. Counting of regular service for the purpose of ACP scheme shall commence from the date of joining of a post in direct entry grade on a regular basis, either on direct recruitment basis or absorption re-employment basis. So commencement of ACP is from absorption or fresh recruitment. In case of Raj Bhavan, it was not a case of fresh recruitment, but a case of absorption. Service rendered on an ad hoc regulation, ad hoc so contract basis was so. The lordship may skip 2 lines. However, past continuous service in another department of the government of Meghalaya in a post carrying identical scale of pay prior to regular appointment through proper channel in a new department, that's what I've submitted, my lords, from one department to another through proper channel, fresh recruitment, without break, shall also be counted towards qualifying regular service for the purpose of the scheme only, and not for regular promotions. Then clause 4, regular service in a post shall include all periods spent on a deputation, foreign service. So deputation period with Raj Bhavan has been included with MTDC, not with Raj Bhavan. Admittedly, from the documents of the petitioner, as well as the document of MTDC placed on record, that the service of 21 years was with MTDC. Then clause 5, minutes, past service. This is the clause which my learned friend is putting emphasis upon. It says another state government / statutory body, autonomous body, PSU, organization, more important department of the government shall not be counted. So it is for appointment in a department of the government. Any other authority which is not a department of the government, the services rendered in that that authority or PSU or any other state government will not be counted for. And this is not the case of Meghalaya alone, my lords. I'll place a judgment of Patna High Court, similar clause. And then, your lordship, I'll place on record the central government OM of MACP, which categorically provides that services rendered in any central government PSU will not be counted for grant of MACP in the central government department. Then, insofar as ACP is concerned, its primary contention, the bone of contention is whether, as your lordship has correctly pointed out, the only bone of contention is between the petitioner and MTDC as to whether the notional increment granted to the petitioner while appointment as a post of supervisor, because earlier she was working working as supervisor, which has a higher pay band, and then she was recruited as fresh recruit on the post of assistant manager in 2010, which was having a lesser financial benefits. So to cover that gap under FR 23, to cover the gap, the notional increment has been granted. So that is the bone of contention, whether that will be considered as a financial upgradation for ACP scheme, or it's a notional increment just to protect her pay and to bring parity to the same scale. That is the bone of contention. If that is the case, as your lordship will head, it will be with the MTDC whether she will be having a qualifying service of 12 years for grant of first ACP or not. Because admittedly, before completion of 24 years, which was required for the grant of second ACP, she left the services and absorbed by the state government. Now, insofar as the state government is concerned, when she was with the state government, MACP scheme came into force, which is applicable to the petitioner because he is working on a terminal post. And as per the eligibility of MACP, required benefits will be given to the petitioner. When the writ was filed, my lords, she was not fulfilling qualifying service requirement. I believe in November 2024, she has completed 10 years. So I do not have the instructions exactly whether the benefit has been given or not given, but that will be done, my lords, in accordance with law.
Given benefit?
Now,
because of the pendency of this case, no addition has been taken yet.
Yes.
So if she has qualified service of 10 years with the state government, necessary action will definitely follow, my lords. Now, the second portion.
Yes. Yes, yes, continue.
Yeah, yes, my lords. The second portion, my learned friend is not pressing as to the upgradation of pay scale. So I don't think I have to labor on that, my lords.
Yes.
If I understand my learned friend correctly, that I do not have to go into that question at all. So, my lord, just to
subject to, my lord, of course, what the state government today, my lord, if they have the prerogative to take care of her requirement and upgrade, then of course, my lord, it can be done at a later stage, of course, my lord. As on date, I'm not pressing that.
That is all.
We're on your first limb of grievance.
Yes, madam.
That's with regard to your past service and non-consideration. Second limb will come later on.
Correct.
Yes,
Yes.
madam.
Yes.
So, my learned friend has started by saying that his primary claim is with MTDC, my lords. This is my submission as well, that primary claim of ACP lies with the MTDC and not with the state government, my lords. Not with the state government at all. If at all, we'll be liable to grant her financial benefits under the MACP scheme whenever she is eligible. Now, my lords, just to I have my learned friend, Ms. Colony, will be submitting, my lords, a document of central government and 2 judgments, my lords.
Did you give him copies also?
My lord, I have prepared.
Yes.
Yes, my lords. On this very short point, my lords, the first judgment is that of Honorable Supreme Court, A.K. Bindal versus Union of India, 2003, 5 SCC 163.
Yes.
My lords, this is on the point which I was trying to canvass. The PSU and government employment is completely different.
Paragraph?
And, paragraph 14 onwards, my lords. If your lordship may please come to para 14.
Yes.
If I read para 14 minutes. Fertilizer Corporation of India and Hindustan Fertilizer Corporation are both companies registered in the Companies Act, with the only difference that they are government companies within the meaning of Section 617 of the Companies Act. What will be the legal position of the government company and whether its employees will be treated to be the government servants as examined in so-and-so case, and it was held as under in para 4 of the report. It is an undisputed fact that the company was incorporated under the Companies Act, and it is a company so incorporated which carried on the undertaking. The undertaking, therefore, is not one carried on directly by the central government or by one of its departments, as in the case of, or by one of the departments, as in the case of Post and Telegraphs or the Railways. After referring to the well-known decision in Solomon and Solomon, Halsbury's Laws of England, some of the other English decisions, the court ruled as under. Therefore, the mere fact that the entire share capital of the respondent company was contributed by the central government and the fact that all its shares are held by the president and certain officers of the central government does not make any difference. The company and the shareholders being officers distinct entities, the fact that President of India and certain officers hold all its shares does not make the company as an agent either of the president or the central government. Again, in para 5, it was held that the fact the minister appoints the members or directors of the corporation and is entitled to call for information, to give direction, which are binding on the directors and to supervise over the conduct of the business of the corporation, does not render the corporation an agent of the state. The legal position is that any identity of the government company remains distinct from the government. The government company is not identified with the union but has been placed under a special system of control and conferred certain privileges by virtue of the provisions contained by section so and so of the Companies Act, merely because the entire shareholding is owned by the central government, will not make the incorporated company a central government. It is equally well settled that the employees of the government company are not civil servants and so are not entitled to the protection afforded by Article 311 of the Constitution. Since employees of the government companies are not government servants, they have absolutely no legal right to claim that the government should pay their salary or that additional expenditure on account of revision of their pay scale should be met by the government. Being an employees of the companies, it is the responsibility of the companies to pay them salary, and if the company is sustaining losses continuously over a period and does not have financial capacity to revise and enhance the pay scale, the petitioner cannot claim any legal right to ask for a direction to the central government to meet the additional expenditures on so on. So it goes on to say that, well, this is the primary contention, that it's even 100% control, appointments of directors are being made by the government, but the company's separate identity, their employees will never be considered as the government employees working in different state departments. MPDC is not a state department, it's a separate company having separate structure, and as I said, we have no control over the recruitment process, sanction of post, service conditions, etc. of the employees, and we cannot control their eligibility as well. So that is one. The second judgment, Chandrasekhar, State of Kerala, my lords, is on pay scale. Your lordship may leave it because it's on the issue of he has request to upgrade of pay scale from 15 to 18, which my learned friend is not working. Then the third one is Patna High Court, my lords, a division bench, where a similar provision of ACP scheme. The issue is at page 4, para 4, page 2, the last paragraph of page 2, my lords, para 4. In light of relief sought in the present list, the issue is whether the respondent is entitled to have benefit of ACP with reference to service rendered as conductor in BSRTC, which is a corporation of state government, with effect from such and such while counting 12 years of service, or is he entitled to have the benefit of ACP with reference to absorption of the service in the post of junior accountant clerk in the district collectorate. So, similar case, my lords. Now, the finding is at page 6. The clause is quoted at top of page 6, if an employee of a public sector undertaking or an autonomous body enters into regular service of the state government, the period of his service rendered from the date of his entry into the government service alone shall be counted for the purpose of sanction of financial progression in the scheme.
Yeah.
Differently worded, but the object is the same, that they are not an employee, so that period of service will not be counted. Then there is the finding that employee will be considered only from that service will be considered only from the date of absorption and not from the date or not service as BRDC conductor will not be counted for grant of ACP balance. And then in the sequence, the last document is MACP scheme notified by the Government of India on 19th May 2009. I'll just show one clause, my lords, at internal page 6, my lords. Clause 10 at internal page 6 of this document. This is how central government, and basically all the states are following the same practice, my lords. Clause 10 says past service. Past service rendered by a government employee in a state government, so central government scheme, so any state government, / statutory body / autonomous body / public sector organization before appointment the government shall not be counted towards regular service. So here also the language is same. It starts with in a state government, but it cannot be read as in a state government or state government statutory body or state autonomous body. It includes PSUs as well. This is the practice throughout most of the, unless and until there is a different rule of some state, but this is the practice which is being followed throughout. That the service under the PSU is not being counted for ACP. But yes, there is an OM of the central government. Insofar as pension is concerned, that service is being
counted.
Government OM taking a decision that insofar as pension is concerned, service is to be counted. That we have counted lots, PSU service, but not for grant of ACP. So this is from the state laws. Now MDDC is to answer the query of ACP and that is it.
Please, Your Lordship.
How long will it take?
For 20 minutes, please.
And reply?
I'm a very short reply. In fact, my lord, just 1 or 2 points just I would like to place, my lord, which my learned friend has just.
Because I have another engagement at 3 o'clock, in fact, yes.
Yeah, 5 minutes I'll take, my lord. 5 minutes.
Should I continue?
Will you continue tomorrow? You won't be here tomorrow.
Tomorrow, my lord, it will be little difficult because, my lord, I have already some pre-schedule.
And day after?
On, my lord, I will be on.
Take your date. We've heard your submissions. Yes. The point is not that.
Thursday, I don't have any issue. Thursday, no?
Thursday is fine, my lord.
Yes, can Thursday.
Thursday?
I'm a bit handicapped today also.
No problem.
Secretaries also. So they just we'll continue for on the after tomorrow. Yes. We've heard Mr. Tripathi's.
My lord.
Yes.
I'm highly obliged.
Not needed to be here because MS Conley is here on your behalf. Yes.
Yes, please.
The main respondent is you. It states.
In fact, my lord, this is not even an adversarial litigation, my lord. This is just a beneficial legislation that we are basically trying to take the benefit of, my lord, for the services I have rendered, my lord.
Earlier, this same person, I think.
She came here for her pensions, my lord. For pensions and
pension and other benefits as well.
And for counting her past services when she joined my governor's house.
The judgment was given by this bench itself.
Yes, my lords have passed this order, my lord.
No connection for the old pension scheme.
Old pension scheme, correct, my lord. Okay. So she's enjoying the pension, of course, my lord, under the scheme. And we are
still working.
She's still working, my lord. Okay. I'm highly obliged, my lord.
Pleasure.
आप इसको भर लो.